Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-1449, American Municipal Power, Inc. et al. Petitioners versus Federal Energy Regulatory Commission. Ms. Murphy for the stakeholder petitioners, Mr. Gossett for the transmission owners petitioners, Ms. Chu for the respondents, Mr. Longstreth for the respondent interveners.
Morning, Ms. Murphy. Whenever you're ready.
Good morning, Your Honors, and may it please the Court. Erin Murphy on behalf of the stakeholder petition. When transmission owners joined the PJM Regional Transmission Organization, they agreed to delegate to the PJM responsibility to plan for the enhancement and expansion of the regional transmission grid to which they were committing their facilities. Yet as things currently stand, upwards of 2/3 of the projects for new transmission facilities to serve the regional grid are being planned not by PJM, but by transmission owners making unilateral determinations about how to address needs that arise when they choose to retire from that grid one of their facilities that has reached its end of life. In the series of FERC orders at issue here, FERC not only sanctioned that lopsided planning regime, but cemented in place a regime under which literally billions of dollars of these end-of-life projects will have their costs allocated locally without regard to whether they have regional benefits. The ultimate result is to saddle consumers like many of the consumers that my clients here today represent with local costs for regionally beneficial projects in which the Regional Planning Authority, PJM, has had virtually no involvement.
And if I could just have you step back a second just to kind of understand kind of regime and scheme. Are stakeholders and members interchangeable?
So generally the stakeholders that I'm here on, there's stakeholders who are members. There may be some among our client group. I'm not 100% certain that there aren't some here who aren't members, but we have members and stakeholders and generally people who kind of put forward the proposal on behalf of the PJM membership.
And is there a document that expressly identifies more than just the stakeholders who are issuing this case?
I don't know offhand kind of where in the record it would tell you the universe of stakeholders. What I can tell you is, the members' proposal that was put forward here was supported by a supermajority of the membership. So it may not be that all of that supermajority is a party to this proceeding.
Because I just want to know how far reaching the implications of any of our decision making goes.
Sure. I mean, I think that your decision making would impact basically the entirety of kind of the PJM universe without regard to precisely who the parties are that are up here, challenging things as members or as parties to the owner's agreement, because ultimately what we're talking about is how to interpret the documents that govern the PJM owner's relationship, the PJM operating agreement, and the PJM.
And then one last question on that kind of setup. How would we view stakeholders versus transmission owners?
So the transmission owners are, they're the parties that own the facilities that kind of make up the PJM grid, and they have entered into the owner's agreement with themselves and with PJM that delineates the differences between their rights and the rights that they have delegated to PJM. The stakeholders and the members are essentially kind of the customers of the PJM transition grid by and large, and some of them, there's overlap between the two. There are some entities, some of my clients are both owners who are parties to the owner's agreement, and they are customers within PJM who take transmission from the grid and are also members and stakeholders and parties to, are part of kind of the membership that works on what the operating agreement is.
And I'll ask the Chief Judge to give a little grace for you because I just needed some of that answer. Thank you.
No problem.
Ms. Murphy, is it the stakeholders' position that all end-of-life projects should be part of the regional plan or some subset of them? I mean, because it seems that there is between both sides sort of like an either or. It's either all of them are left to the discretion of the transmission owners or all of them are with PJM.
So it's not our position that all of these projects need to be regionally planned. We do think that they all fall within PJM's planning authority, such that basically under our proposal, the members' proposal that was the one that was rejected in the second set of FERC orders here, we would have essentially had PJM decide in the first instance when a need arises because a facility has been retired. We want PJM to be involved in deciding, is that a need that gives rise to a project with regional benefits, in which case it should be regionally planned, or maybe it is a project that's local and can be locally planned. What we don't want is a world in which transmission owners get to make that decision for themselves and decide to locally plan projects, even when, as here, it's clear that they actually have projects with regional benefits.
And is that because end-of-life projects are part of an enhancement or expansion?
We think they are. I guess the way I would put it is, I think it's helpful to think about it less in terms of the project and more in terms of the need. Mm-hmm. What happens when you retire a facility that's currently serving the regional grid is you have a need for transmission on the grid. And we think the question of how you should deal with that need is a question that involves planning about the enhancement and expansion of the grid. Now, it may be that, the ultimate determination about the proper project in some instances is something that's pretty minimal and doesn't really have a huge impact in terms of enhancement or expansion. And PJM can say that can be locally planned and you can do it. But the universe of things we're talking about, when you're saying, we're going to take something offline that's currently serving the regional grid, to us, that fits very comfortably within that planning responsibility to deal with enhancement and expansion of the grid. And I think one of the major...
Do you think that's true with respect to the terms of the owner's agreement as it is written now, or that the owner's agreement would require some kind of amendment to make that clear?
I think it's unambiguous within the terms expansion and enhancement. And I think one of the principal problems with FERC's reasoning here is, FERC all but acknowledged that the way they have read those two terms deprives enhancement of any independent force. Because FERC has defined an enhancement to mean only a capacity expansion. And if the only thing that counts as an enhancement is a capacity expansion, then lots of things that in common parlance would be enhancements, things that increase reliability, increase efficiency, increase cost effectiveness, are enhancements that somehow have been read right out of the agreement. So you're not only depriving enhancement of what I would think of as its just ordinary plain meaning, you're really depriving it of any meaning at all and reading this agreement as if the only thing that was delegated is planning authority with respect to capacity expansions. I don't think that's a natural or appropriate reading of the plain language of the agreement.
I'm sorry, will you finish with that one? Yeah. I have a procedural question. You argue that in your brief at least, you argue that the transmission owners surrendered their filing rights to PJM, and you rely on tariff section 9.2, right? Yes. I'm curious about it. You cite it, but you don't seem to make a big deal out of it. What is the term? What is the phrase? Terms and conditions of the PJM tariff mean? What does that mean in the tariff?
So I think the dichotomy we see between 9.1, which reserves filing rights to the owners, and 9.2, which reserves to PJM, is that 9.1 is focused on things that are very specific to rates. And so I think the universe of what we would think of as planning decisions, which is what we're talking about in the first instance here. Obviously, these are planning decisions that impact cost allocation, but that planning determinations in the tariff about who's going to decide what should be built are things that we would fit into that broader language in 9.2.
And so if you're right about that, is the consequence simply that the transmission owners just need to submit their proposed tariff revisions to PJM and follow those procedures? Is that the only difference?
As a procedural matter?
Yeah.
So as I understand it, PJM...
suppose you're right about this.
Yes.
Suppose you're right that this filing right they surrendered. What are the consequences of that?
So as I understand it, PJM doesn't have an obligation or even authority, I don't think, to file something that's put forward just by the owners to change the tariff. So if we're right about that, the changes to the tariff have to come through PJM, through the PJM membership directing PJM as to what the filing should be, which is what happened with respect to our proposal.
Yes, that's the way yours work, right. But does PJM have any choice about that?
So I don't think, I think as we read kind of the filing obligations of PJM, it doesn't have the ability to file something that's just put forward by the owners that isn't within the owner's 9.1 rights.
No, I'm talking about all right, well, tell me what will happen. Suppose we agree with you that
Right.
this has to go back for that reason. What will happen?
I think if you agreed with us, then what would have to come up through PJM is something like the member's proposal, that because it would have to come through for PJM to file it, it would have to be something that the owners got the members to agree to direct PJM to file. So, you'd end up with,
So you would have control over it.
we would have control over what can be filed. And FERC would have the same ultimate question of looking at, probably the member's proposal and determining whether it thought the member's proposal was consistent with the rights of the owners in the owner's agreement and the broader documents here. So, ultimately, I don't want to suggest, we actually care quite a bit about this question of who has the rights to file, because it has broader implications, not just for this case, but for several cases in which we've been having a debate with FERC and the owners for years about what the scope of their filing rights are. But in this case, you'd probably still end up reaching the question of whether who has the planning authority, because the member's proposal was put forward properly to FERC pursuant to the members' rights to have PJM make filings on their behalf. And FERC did address that question in the members' proposal orders, separate from its discussion in the local proposal.
Right.
Is the filing authority question also linked to the substantive question about whether the transmission owners have, authority for end-of-life planning? Because if you assume that they do have authority over end-of-life projects, then doesn't that pertain to their transmission revenue requirements, right? Which is a category over which they retain filing rights. So if they have the authority to plan those projects, then they need the revenue to pay for those projects, and so would have filing rights. So I'm wondering if the two questions are in fact interrelated.
So I think they're related. I don't think at the end of the day they stand and fall together, but I do think they're related in the sense that, we would say it's not kind of terribly surprising that 9.1 is focused on rates and not planning, because that is consistent with kind of the broader dichotomy of what we think is the right understanding of the owner's agreement and the delegated rights under section 4.1.4, that rates and rate determinations are something that owners did reserve the rights to make their filings to FERC about. But planning determinations, that's exactly what they gave up, was the right to do planning for the broader enhancement and expansion of the regional transmission grid, because that was sort of the point. We're joining a grid, we're putting our facilities in that grid, and we're entrusting a regional authority to make determinations about what the needs are and how best to address them for the broader region. So I do think I think there's a reason that, the parties kind of both see them as aligning with their ultimate substantive positions about rights. But at the end of the day, I don't think that there's a reason that, you kind of have to read them such that if you reach one conclusion about filing, that necessarily follows that you would reach the same conclusion about the other.
With respect to the 8.5 section that's dealing with the voting rights, it actually refers to an administrative committee versus PJM. So how does that play into?
Sure, we think that's actually like the critical distinction here, which is that the owners chose to act through the administrative committee. And as we said in our reply, if they hadn't chosen to do that, they wouldn't have been bound by the procedural requirements that apply to action through the administrative committee. They could have, it's not obvious that they had to act through the committee. They could have put out their proposal themselves, but having chosen to act through the committee can only act if it takes a vote. And it did not do that here. It took a vote ultimately on the proposal, but not on that initial step of submitting the proposal to everybody for them, basically to the membership for input. And I do, I just want to be clear that there's, there's a reason we care about this. It actually is sort of what helped them kind of game the timing a bit and jump us in line, because we were ready to vote, have the membership was ready to vote on a proposal. It put out notice, we're going to vote on a proposal in a couple of weeks. And the very next day is when the owners jumped us in line and filed their proposal with FERC. And then FERC was unwilling to consolidate our two proposals and consider them together. So the whole kind of trajectory of how all of this got teed up at FERC and the lens through which FERC was looking at it ended up being controlled by the fact that they filed this, that they put in this filing before we could complete the membership vote on our filing, and they wouldn't have been able to do that if they complied with the obligations to take a vote on the initial step of putting that proposal out for membership input, because there's procedural dynamics that apply to just kind of putting something out up for a vote for the administrative committee in the first.
So you take a different position in terms of there's not a, you think that there should be essentially a vote to put the proposal out before putting the proposal
That's right. If you want to act through the administrative committee, our view is you need to take the vote kind of for both the preliminary step and the ultimate step.
Not a consultation.
To take the vote to do the consultation.
Okay.
And then ultimately you have the vote at the end. So we do think that there are a couple of procedural defects here. But, I also want to be very clear that we think there's fundamental substantive defects with FERC's reasoning.
So, Ms. Murphy, can you say a little bit about if we were to vacate FERC's orders here, what would you have us direct them to do on remand? Consider the two proposals together?
I think it would be, I suppose if there's a couple different ways you could vacate the orders. You could vacate the first set of orders on the ground that there was procedural defects. The procedural defects don't kind of naturally carry over to the second set of orders. Mm-hmm. Now, I think that this court could say, look, that kind of impacted the whole thing, so just please start over. But I also think given that the orders on the members' proposal independently addressed the substantive question of who has the power here, that it would be absolutely open to this court, and we certainly urge the court to take the step of addressing in the context of the members' proposal the fundamental problems with the reasoning that FERC employed, so that we don't go back to square one and just kind of show up here again a year from now in exactly the same, making the exact same substantive arguments in just a little bit different procedural posture. And we do think that both, whether you're looking at this through the lens of the local proposal or through the lens of the members' proposal, that this language in the owner's agreement about enhancement and expansion unambiguously gives this planning power.
Do you think it was arbitrary and capricious for FERC to consider the two proposals separately?
We haven't independently argued, kind of independently challenged the failure to consolidate. I don't quite understand why you wouldn't consolidate. Clearly all of this is arising in the same context. You have here, the same parties aligned in the same substantive positions in the opposite way, and it.
Some of the arguments of the stakeholders go to whether, whether FERC had to consider whether the proposals were just and reasonable, mm-hmm. right? And it seems like it would be very hard to make that determination looking at the proposals separately, because they're two competing proposals. And so therefore they would have to say one is just and reasonable, or neither are just and reasonable, or, something about both of them.
I think that's exactly right. And it goes to what, to me, one of the most kind of glaring problems with the reasoning is the failure to account for the cost causation principles, which are important to both of these proposals. As we repeatedly explained below, the local proposal, sure, FERC's right that it doesn't change the formulas for how cost causation will work, but what it does is the same thing that was going on in the Old Dominion case. It takes a category of projects and says, this category is going to be subject to local cost allocation. We put in a bunch of evidence in the administrative record that this category, just like in Old Dominion, includes significant numbers of projects that have regional benefits. We put in evidence that we're talking about in 1 year alone, like $750 million of these costs. Half of that was misallocated if you just apply ordinary cost causation principles. Now, if FERC were really looking at that proposal side by side with our proposal, under our proposal where we're saying We think there should be a threshold determination by PJM to decide, look, some of these projects, local, fine, they can be locally cost allocated. Some of these projects are regional. And as to those, we need to either have regional cost allocation or at the very least acknowledge that we're not having it and explain why that's consistent with Old Dominion, with Entergy Arkansas. You know, FERC, I think the answer FERC gave to simply say, oh, this filing isn't about the formula itself, so we can ignore the fact that this filing is deciding what cost allocation will apply. I mean, to me, that is kind of classic arbitrary and capriciousness, even without this board having just put out an opinion a couple of years ago saying, in the specific context of end-of-life projects, that FERC has an obligation to deal with cost causation principles, that FERC should presumptively, when you have regional projects, be doing regional cost allocation, and that if you're not going to do that, you need to acknowledge it and explain why. Now, I will say, you know, I think there's a reason that these projects ended up going, you know, why the local proposal designates them categorically for local cost allocation. It's because if you go back, I mean, this is another problem with FERC's reasoning, if you go back to something like Order 1000 that kind of sets the whole stage for all of this, FERC has said that if you have regional benefits, then you not only have to have regional cost allocation, you have to have regional planning. You have to have competition. You have to go through that process that has been set up for the projects that have regional cost allocation. So, you know, there's a reason that the owners want to say, we're just going to put these in the local bucket, because the moment you acknowledge that we're talking about a category that has projects that have tens, hundreds of millions, I mean, you know, over time, we could be talking about billions of dollars of costs that are being, under cost causation principles, misallocated. That not only says we need to allocate the cost differently, it really goes to show why this whole regime that the local proposal has put in place just doesn't work, because we should be doing regional planning, not just regional cost allocation, in instances where we have needs that arise that impact the entire region.
Any further questions? So, thank you. I'll give you some time on rebuttal.
Good morning, Your Honor. May it please the court. David Gossett for the transmission owner petitioners. The legal determination that the owner's agreement is ambiguous has no basis in the controlling document.
Mr. Gossett, could you start with standing?
Of course, Your Honor.
Can you repeated, the commission repeatedly ruled in your favor in this case. And what you're challenging here is their reasoning, correct? Can you cite any case which suggests you have standing under these circumstances?
Your Honor, the commission made two separate legal determinations here. They made the legal determination that the owner's agreement was ambiguous.
Right.
And then they separately made the legal determination that the transmission owners would plan for these specific end-of-life projects. It's that first legal determination is a separate one that has separate consequences.
So I go back to my question. Can you cite a case where
I would cite...
Let me just finish my question. Where a petitioner has succeeded on the merits, but is challenging the reasoning?
I mean, in Sealand, the court talked about how if there was a separate proceeding as a result of the reasoning, it would be sufficient. And in the metric constructors case that we discussed in our reply brief, similarly. But I mean, I think it's important here to focus on what the consequences of that legal determination are, and the fact that the commission never really engaged with that. We submitted a factual declaration in the record that the finding of ambiguity as to the owner's agreement was costing the transmission owners time and money in separate proceedings, in proceedings addressing other forms of...
I read all that. My question is whether that's enough for Article 3 standing. Not all injuries are sufficient to support Article 3 standing. Some are too amorphous or too conjectural.
Of course, Your Honor, but I think we have specified concrete injuries that are not therefore amorphous or conjectural. It is costing the transmission owners time and money in the planning of other forms of supplemental projects, other forms of asset management projects that are not end-of-life projects, but that are today, we are being challenged by the stakeholders and others saying these are, under the commission's ruling, projects that should be must be planned by PJM rather than by the transmission owners. And that's costing us money in the real world today. It's a very concrete injury that we believe is sufficient under.
Mr. Cross, are you saying legal uncertainty is an injury because it creates legal fees? I mean,
No, Your Honor, because it's not the finding of ambiguity is not an uncertainty. It's not uncertain. It has been a finding here that the owner's agreement is ambiguous. So it's this weird circumstance where the actual legal finding is a finding of uncertainty. That's the legal finding here. So it's not. We're not saying that there is uncertainty about the legal finding. There is certainty that the commission has said that the owner's agreement is ambiguous.
There's certainty about uncertainty.
Yeah, exactly.
That creates an Article 3 injury in fact. I don't know if there are any cases that suggest that that's true, to Judge Tatel's point.
I have not found any cases in which the injury specifically is a finding of ambiguity, but here we believe that injury is precise and has directly traceable consequences to our members. I mean, as Commissioner Danley.
If that is reversed, what does it accomplish? What are if that particular finding or reversing on that particular order point, what is that accomplishing? What do you need us to do in that regard? And what's the consequence of that?
Well, the consequence as to this litigation, I would suggest would be that the commission, the court would grant the petitions for review and vacate without remand, without vacater for purposes of the commission to clarify or to rework its orders along the lines it had done 3 times already. Its consequences in other circumstances would be that it would.
I guess I'm asking, are you asking just to delete that particular finding about the uncertainty? And the ambiguity?
Yes, Your Honor. That is what we as petitioners are asking for, is that the court hold that the commission erred in finding the owner's agreement to be ambiguous. And as a result of that, essentially to remand for the purposes of the commission to say the owner's agreement unambiguously gives us the rights to plan the specified end-of-life projects. And of course, it's important to note that the commission said that the owner's agreement was ambiguous, but never actually really relied on that fact. I mean, they said that they were going to look to extrinsic evidence, but then in fact, the evidence they looked to was exactly the kinds of evidence that you would normally look to under Chevron Step 1 or in a contract interpretation case to decide what the contract means, to decide whether the contract's unambiguous in the first place. So they look to history and pattern and practice in the industry. That's exactly the material that the commission itself, in paragraph 14 of the hearing order, said you look to decide ambiguity. So it really is a reach here. It's an agglomeration of power on the part of the commission. I mean, because what does the finding of ambiguity do? It transfers the decision-making about what the owner's agreement says to the commission. I mean, it's exactly what the commission did in Atlantic City, too.
That's always the case in a situation where an agency or a court concludes language is ambiguous. I mean, that's nothing new. That happens. That's inherent in the judgment that something's ambiguous, right?
Yes, Your Honor.
So, I mean, I'm not sure why that's relevant to your standing argument.
I was addressing Judge Child on the merits, Your Honor.
Oh.
I thought her question was a merits question.
Seeking remand
That's
without.
okay, keep going. I'm sorry. If that's what you were doing, I apologize for interrupting you on that. So go ahead.
Yes, sir.
Perhaps seeking remand without vacator is a giveaway that there's no real injury.
I do think there is injury in the context we've said, though, of course, I do also think that the commission, the court, in reviewing the commission's order here, could review this legal reasoning regardless of our standing to bring this case. I mean, it's a legal question for the court to address.
Yeah, any other questions?
Wait, but if, wait a minute. If, I don't want to take this any further, but if you don't have standing, why would we review that judgment in this part of the case?
If we don't have standing, Judge Tatel, we think you could review it in the other part.
I guess, yes, that I agree with you on.
That was my point. It's just
So your point is it doesn't have any
question.
consequences for what this court has to do, correct?
The court has to decide whether the commission erred in its interpretation of the owner's agreement.
Okay, that's helpful.
Thank you, Your Honor.
Thank you,
Okay.
Mr. Bassett. Good morning, Ms. Chu.
Good morning. May it please the court. Susanna Chu for the commission. I'd like to start.
Do you have any views about this standing question?
I'm sorry, Judge.
Do you have any views about this standing issue?
I think, Judge Tatel, you asked exactly the question that the commission has been asking.
Okay.
The commission ruled in favor of the transmission owners. We don't think that that uncertainty, even if it's certain uncertainty, is an actual harm sufficient for Article 3 standing. I think that transmission owners, we received all the substantive relief that they wanted at the commission.
But you agree, even if we agree with you about that we still have to address that issue in the stakeholders part of the case, right?
Right, Your Honor. I think that, even if the transmission owner petitioners have no standing, of course, there's the stakeholder petitioners, which, and that has to be reviewed.
Okay, and just to clean up some discussions from previous parts of the argument, what's your view about tariff section 9.2?
Your Honor, the commission, as we explained in our brief, we think that the transmission owners certainly retained their section 205 filing rights with respect to the tariff. And if you look at the section in its entirety, you'll see other indications that the transmission owners did not confine themselves to only filing rate and transmission revenue requirement changes. For example, at the end of section 9.2F, the transmission owners reserve their rights to assert that other provisions of the tariff should be included within their section 205 rights. That's a JA 2265. When we think applying Atlantic City, the commission did not feel that it could hold that the transmission owners lacked section 205 filing rights here.
Was there any reason that these proposals weren't considered in a consolidated way?
Well, Your Honor, I think Judge Rao made a point about the practicality of reviewing these two proposals. I do want to emphasize that how these cases were teed up at FERC had no impact on the ultimate resolution. The commission objectively considered each of these proposals on their own merits. They're each section 205 filings. They had to be considered under the burden. The proponents of the proposal had to show that it was just and reasonable, and the commission accepted a transmission owner proposal as just and reasonable because it was consistent with the lines that were drawn in the PJM governing documents. It did not alter any actual division of authority. On the other hand, the stakeholder proposal was not accepted as contrary to the lines that were drawn in the PJM governing agreement. And here, I'd like to point out that the commission...
Ms. Chu, separating these out, I think it makes it easier for FERC to kind of put aside the cost allocation issue. It says, well, the transmission owner proposal is not to a specific allocation of costs, and so we're not going to consider that here. And then, taking the proposals separately, FERC seems to have avoided its responsibility to think about how these proposals affect costs, which is an important underlying principle of Order 1000 and 2000, and the sort of the whole idea of regional transmission plan.
Right. So, Your Honor, you're correct that absolutely cost allocation is hugely important in regional transmission planning. But this case, let me emphasize first that this case isn't about transmission planning policy, and the Commission is actively engaged on issues relating to cost allocation outside of this case. For example, in the concurring statement by Commissioner Clements, she discusses the ongoing proposed rulemaking on transmission policy issues before the Commission. That's discussed at Joint Appendix 2061
but can you speak? But what about the cost allocations here? So FERC's position here seems to me very peculiar because FERC's ultimate conclusion is that the agreement is ambiguous. And so therefore it doesn't actually settle who should resolve, who should plan end-of-life projects. So if that's the case, then making a decision that transmission owners plan end-of-life projects will, of course, have consequences for costs because FERC concluded that it was ambiguous. So that by definition, if it's ambiguous, it doesn't then settle the cost allocation. And so by choosing the transmission owner proposal, you are choosing one particular allocation of cost. And then why isn't it incumbent on FERC to determine whether that cost allocation is just and reasonable?
So, Your Honor, it's important to remember this was not a Section 206 complaint. Mm-hmm. So that's what makes this case different from the Old Dominion case. That case involved an identified set of transmission projects, so we knew what they were. And that set of transmission projects, the transmission owners actually made a filing to remove them from regional cost allocation. These are projects that were originally identified as Form 715 projects, which are planned by PJM and typically would have been subject to broad regional cost allocation. But in that case, the transmission owners chose to make a tariff filing to remove them from regional cost allocation, to make them local. Now, this case doesn't involve anything like that.
Why not? Why not on FERC's first conclusion that it's ambiguous? So it is making a change to the allocation.
No, Your Honor, there is no change to the allocation. The ambiguity finding relates to the specific language in the owner's agreement, the expansion and enhancement language. So, of course, the Commission had before it two parties that were advancing very different proposals and saying that the owner's agreement was unambiguous in two opposite directions. So the Commission turned to the language of that owner's agreement, and specifically Section 6.3.4 at JA 2367, which says that PJM shall conduct its planning for the expansion and enhancement of transmission facilities based on a horizon of at least 10 years.
Ms. Chair, I just don't feel like you're answering my question. My question is, if the Commission believes that that was ambiguous, and then they pick the transmission owner proposal in the context of what they say is an ambiguous agreement, then doesn't that have consequences for costs? Namely, that these projects are going to have costs assigned locally.
Okay, I apologize, Your Honor. You're right that there are consequences for costs. Yes.
And if that's true, then why does FERC not have to determine whether that allocation is just and reasonable on a cost causation type of principle?
Right, and that's because there are consequences for the costs, practically speaking, in on the ground. However, these are two proposals that were made under Section 205, and neither proposal actually made any change to the existing cost allocation methods that are set out in the PJM tariff.
Well, I mean, the fact that it doesn't change one particular part of the tariff doesn't mean it, as you say, it does have consequences for costs. So just because it doesn't modify one particular part of the tariff, you're saying FERC is absolved of considering cost causation, against a background where FERC is supposed to be trying to promote efficient, cost-effective regional planning of transmission upgrades for the benefit of the public. So why does FERC not believe it has to consider that in this context?
Well, the commission felt it was not appropriate in the context of these Federal Power Act Section 205 filings. And it felt that the larger competitive considerations that inform the commission's policy concerns, those are addressed in other contexts, right? They could be addressed as they are being addressed in a generic rulemaking about transmission planning and cost allocation. They could also be addressed in a Section 206 complaint filing, which would be under 16 USC Section 824E. And there, that would be a challenge to the existing cost allocation as not just unreasonable. So here we don't have that. This is not a Section 206 proceeding where parties or any party is challenging the existing cost allocation as unjust and unreasonable.
But FERC approved a cost allocation, I think, by approving the transmission owner proposal. Is that incorrect? I mean, in a Section 205 filing, FERC still has to determine that what it's accepting is just and reasonable.
Is correct. The commission accepted it as just and reasonable, but on the basis that it didn't change the status quo. The existing cost allocation remained the same.
But that's my question, right? Because actually on FERC's view, it did change the status quo because FERC believes that the agreement was ambiguous. So if FERC holds to the idea that it's ambiguous, then by accepting the 205 filing, it is making a change. It is not the status quo on FERC's own reasoning. So at least at a minimum, FERC's internal reasoning is unreasonable, maybe, or arbitrary and capricious. Like, I don't know how FERC's reasoning kind of all lines up to reach the conclusion that it did.
Well, I think the commission, you know, what happened is that the commission is looking not just at this one provision, but it's looking at the operating agreement. It's considering PJM's position that PJM does not have this authority and cannot do this planning, and is looking at the operating agreement, which specifies that and it's important to remember that PJM doesn't necessarily plan all regional projects. I mean, there's substantial overlap to some degree here. I mean, there are projects that that may address a local need and also a regional need. And under the existing tariff, what happens is PJM does get this information from the transmission owners, and PJM has the opportunity to plan a regional project, you know, with the information about this local planning project. And so there's significant complexity here, but the commission ultimately found that the governing documents do specify, you know, they do specify that transmission owners retain certain planning authorities. They retained planning authorities for supplemental projects, and that's basically all of the projects that are not included in the PJM Regional Transmission Expansion Plan. So what the commission was accepting was a proposal that just formalized the process for the planning of these projects. Previously, they would have been planned as supplemental projects, or if they had been identified on a utilities form 715, they would have been planned by PJM, such as the projects that were at issue in Old Dominion. I'm sorry if that doesn't answer your question. I can try again. All right, I do just want to clarify that the orders don't cement anything in place. You know,
I'm sorry, they don't what?
They don't cement anything in place. I mean, this is the current state of play in PJM. However, to the extent that parties have concerns about a specific cost allocation, they can always bring these concerns to the commission as a Section 206 complaint. And of course, these issues are being considered in the rulemaking proceeding. So
but
as
that
to
was sort of, isn't that what the previous orders, like Order 1000 and Order 2000, was designed to prevent, right? By creating kind of an overall system of regional planning to sort of avoid this like case by case determination about whether a particular cost allocation was unjust. I mean, that was sort of, I mean, that could have happened even before.
You're right. That is the motivating, one of the motivating concerns of Order 1000. But PJM does do regional planning through the Regional Transmission Expansion Plan, and it's
But
specified.
FERC has now taken out of PJM's authority all end-of-life projects, which are a substantial part of what's going to be, I mean, especially in the Northeast, where expansion of the grid is extremely difficult because of regulatory and other hurdles. I mean, the whole ballpark is enhancement and upgrading of systems. And FERC has said that all of that is now left to local transmission owners.
Right, the commission.
So how is that consistent with orders 1000 and 2000?
Well, the orders 1000 and 2000 did recognize that not all planning was regional, that, there are projects that continue to be local in nature. And that's where the commission found here that a replacement of equipment continues to be local in nature. It falls on that side of the line. I mean, I understand your Honor's concerns that, yes, this is a significant number of projects, but it is important to remember that the PJM does plan some of these end-of-life projects, and those are the so-called Form 715 projects.
Any other questions?
Yeah, I want to take you back to my 9.2 question.
Yes, Your Honor.
I'm just looking at the language of this. I don't see why it isn't a surrender of their filing rights here. It says a PJM shall have the exclusive and unilateral right to file ellipses, make changes in or relating to the terms and conditions of the PJM tariff. With one exception. Why is that not a complete surrender of their 205 filing rights? I don't understand that.
Your Honor, my understanding of PJM as a practical matter.
No, tell me about this language. Just look at the language. 9.2.
I'm sorry, you're looking at
9.2.
9.2.
Yeah, look at the language. I don't mean to be a textualist here, but that's what we are. 9.2, you got it?
Yes, Your Honor.
Okay, PJM, it says, shall have the exclusive and unilateral right to make changes in or relating to the terms and conditions of the PJM tariff. That sounds like what this is all about.
Right, Your Honor. As a practical matter, PJM did make the filing for the transmission owners to FERC. My understanding, and I think the Council for Transmission Owners would be better able to discuss the
I thought they didn't go through the PJM procedures to make a filing. Didn't they file it directly?
The cover letter and all of that was prepared by the transmission owners.
Yeah.
The actual filing,
Right.
my understanding, the actual filing was done by PJM.
Huh. What, do you have something in the record that says that? What would you point to there?
That I don't know if I can point to anything in the record. That might be a function of the.
I mean, the transmission owners, sorry to interrupt, they're arguing that it was not done that way. That it didn't go through PJM, at least as I understand it.
Right, they did file, right, so they and the stakeholders filed separately.
Right, exactly.
That's correct. But my understanding is that PJM actually made the filing. So,
Okay.
but yeah, and I think, Your Honor, it's the overlay of Atlantic City and also the provisions, for example, the owner's agreement that says that, rights not specifically transferred to PJM remain with the transmission owners.
Yeah, but this, okay.
But I hear you, Your Honor.
This says exclusive and unilateral right to file. All that leaves for them is what's in the end of the sentence. So, all right, well, we can pursue this. That's interesting that your point, I hadn't understood that this was actually submitted by PJM through their procedures.
That's right.
That would certainly solve the problem if that's the case.
No. Okay, thank you very much.
Thank you.
Thank you, Your Honors, and John Larson for the transmission owners. We've kind of been led down a path here, and I think we're down the wrong path, and I'd like to kind of get us on the best.
Wait, who's the we? Us or you?
Well, I think.
Could be us. That happens in FERC cases often.
First of all.
So we get to go down any path we
Yeah.
First of all, FERC decided this issue, okay? FERC held that the agreement was ambiguous, but FERC decided this issue. FERC decided that transmission owners have the authority to plan end-of-life projects, period. They decided and it's done. There's no ambiguity about that decision. It is based on the finding FERC had that we disagree with, that the agreement was ambiguous. But looking at that agreement, FERC absolutely decided that end-of-life projects are planned by the transmission owners. There's no doubt about that. That's why we're defending FERC in this case.
Did they decide that under the agreement or as an amendment to M3?
They decided it. So amendments to M3 were proposed by the transmission owners. FERC decided that those amendments should be accepted, and this has nothing to do with, separating out the issue. We can get to that later. FERC decided those amendments should be accepted because end-of-life projects had always been planned by the local TOs. PJM has never planned these end-of-life projects, at least as they're defined here, where they don't expand and enhance the grid, and when they don't address some other regional planning need of PJM. So there's no change in that either. So this discussion we've had that projects have been dedicated to local planning, there's some kind of change. There has been no change. PJM has never planned these projects, and that's never gotten in the way of regional planning. So there's no change on that. We've always planned these projects.
I mean, what does it mean for there to be no change if both parties disagree about what was required by the tariff and the agreement, and they both propose amendments?
Well, first of all,
one to M3 and one to the agreement.
First of all, the parties to the owners agreement, which is the fundamental basis of all this, because the owners agreement decides, based on Atlantic City, what powers the transmission operators have and what powers PJM has. The parties to the owners agreement are PJM and the transmission owners. Those parties don't disagree. The parties to the owners agreement fully agree that these end-of-life projects have always been planned by the transmission owners, will still be planned by the transmission owners, and that's not going to affect PJM's regional planning. So the parties are in agreement on that. The parties that are not in agreement are strangers to the owners agreement, LSP, and well, I guess they have some small part of their group. But basically, the primary driver of all of this is somebody who's not an incumbent transmission owner who's trying to come in and get authority to plan the projects that have been reserved to us. Now, we had a long discussion about cost allocation and all of that. I think this is what you have to understand about that. The regional cost allocation in Old Dominion, in all these cases, there's regional cost allocation when there's regional plan. Okay, here there's no regional planning. There has never been regional planning of these projects. It's always been local planning. So when the petitioner, when Ms. Murphy talks about, Old Dominion and cost allocation, she's putting the cart before the horse, because in those cases, there was regional planning. Because there was regional planning, there was presumed to be regional benefits. And because there were presumed to be regional benefits, we have this 50-50 system where in the regional planning side, half of it goes to the whole PJM, all of the load, and half of it goes to the people actually getting the flow. Okay, in this particular case, there's no presumption of regional benefits from the regional planning because there has never been regional planning of these projects. They are local projects. They do not expand and enhance the grid. They're not planned to expand and enhance the grid. So we're just on the completely wrong track here when we're putting the cart before the horse here, saying, well, FERC had to consider regional cost allocation.
Why is an end-of-life project not an enhancement?
Because it's not planned to enhance the grid. It is planned to replace the project. There may be, and FERC explained this very well in the California orders. Those got appealed. I think LSP appealed those. That got settled.
Just focus on the word enhance.
Right.
Why is upgrading, or why is replacing, firming up a transmission line not an enhancement?
Because the question is not does it have some enhancing effect? The question, was it planned to enhance or expected? But we're talking about planning here. And this is an allocation of planning responsibility. So the plan to replace the plan is to replace the project. It's not to upgrade it or enhance it. Now, you may have an incidental enhancement effect, but the question is, what's the planning? And I need to go back to this to talk about this allocation because it's very central to all of this. What's left to the transmission owner planning? What's left to the PJM planning? There are specific planning authorities, regional planning authorities that were given to PJM by the transmission owners. Because you have to remember, this is what Atlantic City was about. We had millions, billions of dollars in assets. We were being asked to give control of those assets over to another entity. Okay, people don't do that just willy-nilly. We think it would be a good idea if they had this all. This is our property. We have the right to control this property. And now all of a sudden people are coming in and saying, but we think it would be nice for regional planning purposes if you gave up control of our property. Well, we thought of that. We litigated it in Atlantic City. We got a strong decision from this court that they can't force us to give up anything we haven't given up. Now what we're saying is, well, because of this language of 9.2, we somehow gave up our right to all of this planning. We set out very, very specifically in the owner's agreement. All they get is the power to plan for expansion and expansion.
If that's correct, though, why isn't it within PJM's authority to determine what should be part of the regional plan? As an enhancement or expansion?
It is, and this is another very important point that's been missed. When the transmission owners propose a end-of-life project, they have to notify now. We agreed to that. We notify PJM. Here's what's coming down for the next 5 years. Here are the end-of-life projects that are coming down the pipe. Okay, PJM can look at that and can say, look, you say this is just a replacement. But we're looking at it, we've got our regional planning, and we have specific planning authorities that you've given us, Atlantic City. Under Atlantic City, we said that's what we gave them. The right to plan for reliability, the right to plan 715 projects, the right to plan economics. So PJM can say, look, we have this authority for regional planning for all of the good reasons we talked about with Order 1000, Order 2000, all that. We have this authority. And so what we're saying is you're proposing an end-of-life project. But we think actually it overlaps with our planning responsibility. We've identified some reliability concerns in this area. So what we're going to say is we're not going to just let you build that project. We have exercised our planning authority, fully recognized under Attachment M3, Part 5 of the applicability section, JA 2301, when there's an overlap between the local project and the regional project, PJM gets to plan that project, and it gets to assign the project, and Ms. Murphy's client can build that project. That's for an overlap. We can't stop that. Transmission owners can't stop that. So that protects this regional planning concern. Now, if PJM decides that, yes, this plan has, this project has a regional benefit, then the cost allocation rules that Ms. Murphy is talking about come into place. You've got regional planning. Now PJM has within its authority taken this regional planning. Now you've got a regional project. Now you presume the regional benefits. So now this 50-50 system that she'd like to apply to these local projects makes sense because it's regional. But when PJM doesn't do that, when PJM says, no, there's no overlap here, it's solely a local project, then it stays in the local project and it stays in the local zone, and that's always been the rule. And it's not changed by this.
Are you saying that PJM can override a transmission owner's decision to locally plan an end-of-life project in every instance?
No, in every instance within PJM's delegated authority. So when PJM says we have the authority to plan for reliability,
my question is, can PJM assert that we believe this is an enhancement and then make it part of the regional plan?
They can assert that. Now, obviously it has to be within their authority, but we assume that PJM asserts it. And look, that's why PJM is on board with this. This is affecting PJM's regional planning.
Who decides whether it's within PJM's authority at that point?
Actually, that's an interesting question. So here's the way it actually comes out.
Wouldn't it be ultimately FERC?
let's put it this way. If we got into a disagreement with PJM and we said that PJM was asserting authority outside the owner's agreement, which is our contractual, protection for our property that we gave them, ultimately, I suppose, it can wind up with this court. But basically, we really haven't had those disputes. And we certainly didn't have this dispute here. PJM fully agrees this is not affecting them. That they understand they only got some authority, they didn't get this authority, and this doesn't come in. But the answer to your question is yes, if PJM asserts that and wants to put it in the plan, we cannot stop them from putting it into the plan. I mean, I suppose we could try to argue it doesn't really create reliability, but we would never do that. It would never come up. If PJM wants to build the project, PJM can direct building the project. We can't do anything.
So then
Now,
why does PJM care then in this context? Or why do the stakeholders,
PJM cares because PJM knows the whole history of this. We've had a whole system set up for now 20 years where everybody understands, what's regional and what's local. We've all been working under this system for 20 years and it's protected our property rights. Now we have a third party to all of this, LSP, with some state folks and some, transmission owners, I guess they got on their side. Now we've got them coming in and trying to upset the whole apple cart. Now I understand why they're trying to do that. They want to get their hands on these projects, but these have been projects that were reserved to us under Atlantic City. And by the way, this isn't the first time LSP has done this. This is the third time they've been here this year trying to get their hands on this stuff. They're not entitled to it under our agreement. They're just not. PJM agrees. PJM knows the deal. When the stakeholders came with this proposal and said, hey, wouldn't it be nice if we could have some competitors come in and get their mitts on the transmission owner's property? LSP says that's fine. The regulators say fine. They're always after us. Sure, why not? Let's throw it up a little bit. But that's our property. That's what Atlantic City was all about. In Atlantic City, FERC said,
so
just like we've been saying here.
Isn't the whole concern, though, is that, yes, it's your property, but if there's no competition and no regional planning, then consumers are at the short end of the stick when there's no competitive bidding for improvements to the transmission grid?
That's the argument they made. And actually, that's why, yes, it all sounds good in the abstract, but that's one of the reasons we made our standing argument is when you really look at what's going on here, that's not what's happening. First of all, it's often nice if somebody has property and let somebody else compete for their property. Yeah, that might be competition. The point is we reserve this right. It's our property. But the second point is the idea that we can engage in all kinds of inefficient planning or inefficient process. It's just not true. First of all, if there is efficiency in regional planning, PJM can say, yes, we've identified that this is in our planning process, and we're going to build that project. If PJM says no, and we build the project in our local zone, we can't recover costs for that unless we go to FERC, get it put in our transmission rate base. They have the right to discovery in that process. They can look at everything. They can look at everything in connection with that project and say, it should have been better. There's also prudency reviews. So the notion that somehow because LSP isn't allowed to come onto our rights of way and take over the projects that we reserved ourselves under the agreement, there's going to be a huge downside to consumers. It's just not going to be. First of all, they can't come onto our rights of way anyway. That was part of our standing argument. And they say in response to that, well, maybe state law lets us do it. Maybe it does, maybe it doesn't. Sounds kind of speculative to me. Federal law does not do it. But the real question is, we reserve in Atlantic City, affirmed by this court, a very strong opinion. And really, just to back up again, the whole point of Atlantic City was FERC said, just kind of what the argument is here now. Regional planning is good. Wouldn't it be nice if we gave PJM all of this regional planning authority? And the transmission owners came and said, well, that's our property. We reserved rights to that. You can't, FERC, FERC was on their side back then, and this court said, you cannot do that. You cannot, just because you think it would be nice for regional planning purposes, take the transmission owner's property and give it over to PJM when they haven't agreed that. The transmission owners, it's a voluntary RTO. We have to voluntarily give up our authority. We did not give up our authority, and we did not give up our authority on these end-of-life projects.
So put another way, Put another way, from your point of view, there's nothing ambiguous about this, correct?
There's nothing what?
Ambiguous.
Well, we don't think there's anything
That's my
ambiguous
point.
about it.
That's your whole argument, right?
FERC did think there was some ambiguity as to whether we gave up these rights or didn't.
Yeah.
We strongly disagree for the reasons Mr. Gossett said. But the bottom line is FERC ultimately decided we didn't give them up. They decided that issue. There's no ambiguity about FERC's holding. They decided we didn't give up those rights.
Yeah, okay. All right. That is all very, very helpful to me. Could you be equally helpful on the language of tariff 9.2 for me?
Yes.
Could you please just look at the language?
I understand.
And tell me, you've heard me ask this question at least 3 times.
I have.
Okay. So what from your perspective is the answer to my question?
Okay. First of all, 9.2 gives rights to PJM. It doesn't give rights to stakeholders.
I understand that. I get it.
And as a matter of fact, it expressly distinguishes PJM from the members committee.
I get it.
They can
Okay.
Yeah. Okay. They can consult. So it says in B, PJM can consult with the TOs and the members committee, but
I just want you to focus on the language that says, which states that PJM has unilateral control over filings regarding the terms and conditions of the tariff. That's the language I want you to focus.
Well, except as described in 9.1a. And of course, 9.1a has very broad authority for us to reserve our rights under.
And what precisely in 9.1a reserves the rights over EOL?
Transmission revenue requirements or transmission rate resigned under the PJM tariff. Any provision governing the recovery of transmission-related costs by the transmission owners. So, for example, by the stakeholders' own assertion, they're saying if we succeed in obtaining local planning authority for this in our proposal, that will all be locally charged, will all go into our rate base. So it definitely affects our rates under 9.1a. But look also, as Ms. Chu pointed out, look to 9.1f, where it says the transmission owners reserve their rights to assert that other provisions of the OAT should be included within their Section 205 rights, and PJM reserves its right to contest such assertions. That's very important because that goes to the issue, and that goes to 5.6 of the owners agreement. Having been through all of this discussion and litigation in Atlantic City to fight FERC's attempt and people trying to piggyback on FERC's attempt to get at our transmission assets, we made very clear in the owners agreement that PJM only has this authority for expansion enhancement and the other specific authorities given, reliability 715 and all that. And most importantly, anything we didn't expressly delegate in the owners agreement to PJM, we retain those views.
Can I just get you to step back? So would I be wrong if I said, and I'm trying to restate your position here in a way I might understand. Your point is, you did not surrender. The transmission owners never surrendered their authority over EOL projects.
That is correct.
Well, let me just finish. Over EOL project. And it would have made no sense for them to surrender their 205 filing rights over those projects.
Correct.
Is that the point?
Correct.
Do I have it?
Correct. That's exactly right. And that's what FERC held. FERC held, look, the issue is what tariff rights we gave up. We didn't give up these tariff filing rights. Therefore, under Atlantic City, we get to reserve them.
And was transmission owners filing in this case through PJM or directly to the commission?
I think our first filing, I think we made directly. That's signed by my partner. The stakeholder, but they do have authority. And this is another thing about, how the filing system works. So we can delegate to PJM our authority to make filings. And that's mostly just so the tariff, it's a long tariff, it's very complicated. That's mostly just to make sure it all works together.
I see.
I don't understand. Yeah. Oh yeah, I'm sorry. No, I'm sorry, I'm wrong about that. It was on our firm's letterhead, but it does say in the note, pursuant to Order 714, this filing is submitted by PJM on behalf of the PJM transmission owners as part of an XML filing package that conforms to the Commission's regulations. And the reason for that is because It's a long time. We want to make sure everything fits together, right? And so that PJM dots the i's and crosses the t's, that they're doing it on our behalf. But see, that's where 9.2 comes in.
So this whole argument that the transmission owners surrendered their rights is just a red herring because PJM submitted it anyway, right?
I think, first of all, that's correct.
Okay.
Second, it's an absolute red herring to say the stakeholders can control the filing under 9.2. It's absolutely clear in 9.2b they can. As a matter of fact, they can't veto or even delay the filing.
Well, I don't think, I didn't read their argument that way.
Okay.
I just read their argument as saying not that they could control it. They were looking for a ruling that from this court that only PJM could make the file.
Right, but PJM did
and
make
your
our
point
file.
is PJM did make the file.
PJM did make the
So
filing.
who cares, right?
Yeah,
It's done.
that's right. PJM did make the filing, so who cares? But then the second issue is, the whole issue is this allocation of authority between PJM and the transmission owners. So if we had made this filing and PJM had said, no, that's within our planning authority, that's within, that we need this for, regional planning authority to meet reliability and all that, PJM would have said no. They just like they did with the stakeholders, they would have disagreed with us. And as a matter of fact, there's actually a provision if there are disputes regarding the filing rights, we go ahead and do that. But none of that is really an issue here because PJM agreed with us. PJM had been through the Atlantic City case. They lost it, right? We won it. Okay. They didn't want to have that fight again. They know what the rules are. We know what the rules
Okay,
are.
Mr. Longstreth, let me see if my colleagues have any further questions. Judge Tatel?
The only other point I want to make is they argued that somehow this whole issue on the filing thing, which all doesn't matter, but we stole a march on them somehow because we filed ahead of them. They didn't come in second because we stole a march on them. They proposed their thing and they lost. They had a failed vote. So the idea that somehow we created this system that created a bad situation for them and how this was all set up and that FERC couldn't decide. I mean, FERC didn't consolidate the cases. Our filing was about our rights. It makes perfect sense for FERC to decide our filing based on our rights.
Thank you, Mr.
But the idea
Longstreth.
that somehow they were disadvantaged, they were last because they lost a vote, not because of anything else. Thank you.
Okay. Mr. Gossett, I believe you're going to do the first rebuttal. I'll give you 2 minutes.
Unless the court has any questions for me, I'll actually wait for rebuttal. I think the issues of standing ambiguity have been addressed and nothing new came up unless the court has any.
Can I ask Mr.
Yes, of
Longstreth one more question?
Oh, sure.
I'm sorry.
Yeah.
Can I just ask you one more question?
Mr. Longstreth?
Yeah, you say, I'm looking at page 25 of your brief. I'm still focused on 9.2 here. You say that the phrase means only, quote, the terms and conditions of interconnection, point-to-point transmission services, and network transmission services under the tariff. That's what you said.
I'm sorry, are you trying to ask Mr. Longstreth a
Yeah.
question? Oh, I'm sorry, I hadn't understood that.
I'm sorry.
I'll let
Yeah.
John come back on.
I just, yeah. Is that okay?
Yeah, sure.
Could you just answer that question about this sentence in your brief? Do you see where I am? I'm at page 25. You say what this means. This phrase, this 9.2 language means only, quote, the terms and conditions of interconnection, point-to-point transmission services, and network transmission services under the tariff. Right?
Right.
Do you have a cite for that?
I'm not sure that I do. That is the understanding that we've had and the feelings that we've had.
I mean, that's consistent with what you were saying all along. I just wondered what you would cite. That's all.
Yeah, and I'll look at it and see if we have it. I think we put that in because that was the understanding. People have been working for this for a long time. But the point is, thank you.
If you have a cite for it, I would appreciate it. Sorry, but thank you.
That's fine. No.
Thank you.
Yes, I will hear from Ms. Murphy now. Thank you. I'll give you 2 minutes.
Thank you. Just want to make a couple of points. First, While the interveners love to talk about LSP and their fear of competition, I want to be clear. I'm standing up here on behalf of about a dozen different parties, including the People's Council for DC, the New Jersey Rate Council, the Public Advocate for Delaware. These are organizations that are designed to be here on behalf of ratepayers who are very concerned about the out-of-control costs that they are facing because there's no accountability for these projects. So sure, competition is part of this, and I have clients who want to compete, but that is by no means the only reason that I am up here today or the only parties that we are up here on behalf of. I want to also clear up some confusion, I think, that was generated about what PJM can do under the local proposal. Yes, if PJM is planning something else that it determines kind of obviates the need for an end-of-life project, it can say, you don't get to do the end-of-life project because pursuant to some other planning we've already done, that project isn't necessary. But what it can't do is actually review these end-of-life needs on a case-by-case basis and say, hey, does replacement make sense here? Is that what's in the best interest of the grid? Should we maybe be thinking about a line somewhere else? Is what would enhance and expand the grid in the best manner? Maybe not to replace this facility at all, because we don't need lines bringing power from coal mines in West Virginia anymore. We need them bringing from wind farms on the coast of Virginia.
So, Ms. Murphy, you disagree with Mr. Longstreth's characterization that PJM can override a decision on an end-of-life project?
I think he was being very, very, careful about his wording. There are circumstances in which PJM can override, but they are very narrow. They are circumstances where PJM, pursuant to other planning authority, is basically, pursuant to.
So not pursuant to its general.
There's nothing in the local proposal that says, hey, we're going to ask PJM if they think we should do this end-of-life project, and if they say no, hands off. It's just that if there's overlap between some other project that PJM is planning pursuant to some other authority that has nothing to do with the need that's arising by virtue of the retirement, PJM can say, hey, we've already got this, so in this instance, you don't get to do the project, or we need that project to be part of this project. What we wanted was exactly what I think was it. It sounded a little bit like they were saying is what exists and it's not, which is something where PJM gets to look at these projects and say, should they happen at all? Should they be regionally competitive? Should they be locally planned? The last thing I just want to talk about just a little bit is the cost causation and Old Dominion and Section 205 versus Section 2. I mean, for one thing, Old Dominion was not a Section 206 case. It was a Section 205 case that was almost exactly like this one. What had happened was there was a 205 proposal to take a category of end-of-life projects and say that category of end-of-life projects should be categorically set for local cost allocation. And it happened, part of the reason there was objections to that was the particular project at hand, the Old Dominion project, demonstrated that there were projects within that category that had regional benefits. And what this court said was, the cost causation principle focuses on project benefits, not on how the particular planning criteria were developed. So the notion that it kind of started local or it doesn't really matter. What matters is FERC needs to confront the problem that you have projects here that have regional benefits. And I don't think, FERC didn't even rely on the idea below that you can fix all of this through a 206 filing, but I think there's a reason for that. It's because the 205 filing says, this is the filed rate. We've decided that this is right. A 206 filing, it doesn't allow us to come in and change the planning. And it only allows us to come in and say, you got the filed rate wrong, which of course is arguing with one hand tied behind our back, because we're fighting against what has already been deemed to be adjusted.
And do you think that type of case-by-case 206 filings would be inconsistent with the framework of regional planning and the other FERC orders?
I don't think it, I think it doesn't solve the planning problem, because it's really just about cost allocation. And here, it might help address the problem, the inconsistency with this court's precedent, because this court's precedent requires cost allocation without regard to planning. But FERC's precedent actually says, hey, if regional cost allocation is required, then so too is regional planning. And I don't understand the Section 206 filings to allow reopening of that question about who should have planned this, how should this have been done in the first instance. all it is, I mean, don't get me wrong, like we'd love to get some money back if there's going to be projects that end up producing unjust and unreasonable rates. But that doesn't solve the more fundamental problem. I mean, it's kind of striking for me that FERC said this case isn't about transmission filing policy. That's all. That's first and foremost what this case is about, is who's going to be doing the transmission planning. We think that if you're talking about a category of projects that involves things that are going to have regional impacts, that the regional planning authority should be involved.
Any further questions? Thank you, Ms. Murphy. Thank you to all counsel for their arguments. The case is submitted.
Case number 22-5058. Thomas Massie, the Honorable, in his official and individual capacity appellants, versus Nancy Pelosi, the Honorable, in her official capacity only et al. Mr. Weist for the appellants, Mr. Letter for the appellees.
Morning, Your Honors. May it please the Court. I wanted to begin my argument this morning by addressing the defendant's speech or debate immunity arguments, which formed the predicate of the district court's dismissal in this case. This court's precedents direct courts to look at what is the act that is going on to determine if it's legislative and subject to immunity or if it is not. And here I want to focus the court in. This is not about the substance of the rule in terms of this immunity. This is about the act of enforcement. And the act of enforcement that went on here was a deduction in pay. In other words, this is a claim for illegally withheld pay.
Wasn't it really a fine, though?
Your Honor, that's the nomenclature that they got, but let me address how that's collected.
Pay is not reduced continually over time, like there's no reduction in salary. This is a fine for the non-wearing of the mask.
Your Honor, there is a deduction in compensation here because of the method of enforcement. This isn't a garnishment that goes out. This is
the amendment doesn't say, the 27th Amendment doesn't say reduction in compensation. That's not what it says. That's not what it says.
Your Honor, the 27th Amendment specifically says no law varying the compensation.
Varying the compensation.
Varying the compensation, which is an increase or a decrease.
Right.
And so we're not only talking about increases, and that's the substance of 27th Amendment argument. And
But I thought you were going to talk about speech or debate immunity. This is the merits.
Right, Your Honor.
So why don't you talk about the immunity question? And maybe you could start by distinguishing this case from maybe you could distinguish this case from Consumer Union and McCarthy.
I would be happy to, Your Honor. Consumer Union did not deal with an out of, in fact, that case dealt with press access, as I recall.
Right.
Right.
Yeah.
Your Honor, the United States Supreme Court has already addressed this compensation issue, and that's why I wanted to begin on the speech and debate issue with focusing in on what is the act that's going on here. And the act that's going on here is illegally withholding pay. That's our claim and our contention. Now, I understand we're going to proceed to the merits, and I'm going to argue that in a couple minutes, but I want to focus on the immunity issue. What is the act? What is the beef, if you will? And it's illegally withholding pay. The United States Supreme Court in Powell versus McCormick has addressed that issue. And it has said when it comes to pay, and Powell, by the way, Your Honor, is a case that was all about the withholding of pay. He was initially excluded from Congress, Congressman Powell was, But by the time it came up to the United States Supreme Court, what was the beef at that point was the illegal withholding of pay. They said that's the part that's not moot. And they said when it comes to that illegal withholding of pay, and that was the claim that Congressman Powell had, there was not immunity for that. The U.S. Supreme Court has ruled when we're looking at the act, and the act here is the withholding of pay, there is no speech or debate immunity for that. There's an on-point U.S. Supreme Court case on that, and that's Powell.
Isn't the withholding of pay one of the reasons, arguably, why the plaintiffs here have standing? Because they have a pocketbook injury. Otherwise, I think standing might be more in doubt.
Certainly, Your Honor. Of course, I suppose, notwithstanding the immunity analysis, anytime there's discipline imposed, there could be, tangential effects. But certainly the pocketbook harm here is why they have standing. But it's also why there's not speech or debate immunity, because the U.S. Supreme Court has addressed it in Powell. When it's a pay claim, and that's what it is, this isn't about it's not like Congressman Rangel in the Rangel case where he's having to sit in the well of a house and, have a censure read to him. We're dealing with the deprivation of pay. And the United States Supreme Court in Powell dealt with exactly that. There was rule enforcement. There were ethics things that predated that. It was all enforcement of the House rules. But why was there no speech and debate immunity?
Wait, can we just, since you're talking about, let me just ask you about this. I want to get around to Powell this way. In gravel, the court said it has the power to, it says it has the judicial power to determine the validity of legislative actions impinging on individual rights. That was Powell, right? His right to serve in Congress, right? Individual rights, and Dombrowski and all these other cases involved persons with individual rights, right?
Right.
2 non-members and 1 member not yet sworn in, but that's not the case here. Your clients are members of Congress, right?
But Your Honor, so was Congressman Powell.
Yeah.
By the time that case came up, he had been excluded. They weren't adjudicated. The Supreme Court was not adjudicating necessarily the exclusion, although that was part and parcel with it. Really what they were dealing with was the legal withholding of pay. That was the issue when it came up to the United States Supreme Court in Powell. And they said no speech or debate immunity for that. We can get to the merits of it. Why? Because we're dealing with an administrative action. It's just like Kilbourne when you sent the sergeant at arms out to go and enforce a congressional order. Certainly the members of Congress that enacted that rule, they've got speech or debate immunity. The sergeant at arms does not. And that was also the holding of the U.S. Supreme Court in Powell. We're dealing with the withholding of pay.
Okay, but I take you back to the proxy voting case. We gave speech or debate immunity to the staff who administered the proxy voting rule. They had speech or debate immunity.
And they did, Your Honor, because that dealt with the actual voting on the hall of the House. That did not deal with administrative enforcement of rules, which puts us on point with the Powell.
No, the staff was implementing the rule adopted by Congress on proxy voting.
They were, Your Honor, but
how's that any different from this case?
Absolutely, it's distinguishable. In that case, you are dealing with the actual processes of the function of voting. That is core speech or debate. Here, you're dealing with withholding of pay. In that case, it is speech or debate immunity. In this case, it's Powell. And it's Powell because it's the withholding of pay. It was the exact same injury that the U.S. Supreme Court held was not speech or debate in Powell. That's what we've got here. We've got a pay claim here. That's what this is about.
What if the fine had been imposed? I mean, what if they were just sent like a fine, through the mail saying, please write a check for $500. And so there was no withholding from their paycheck. They were just sent a fine, like a parking ticket.
Right. And
would that make a difference?
It could, Your Honor. Here, there was no statutory basis to actually enforce it. It's not like there was a garnishment statute that the speaker could go out. And what's interesting, at least in terms of how this got implemented, one of my clients who's got a side business, Congresswoman Green, she just maxed out her withholding. She pays $1 every month towards this fine. We'll never collect it from her because she figured out she's independently wealthy. I can tell you, Congressman Massie's wife, she is well aware of the withholding of pay because that's their primary source of income. And so, again, we're dealing with a deduction of the paycheck itself. And
it seems like you're putting a lot of weight on the way that the House is enforcing the fine. And I'm just wondering if, the enforcement was just done in some other way, then would there be speech and debate immunity? Because you're suggesting the immunity turns on the way that the fine is collected. And that seems, I'm not sure that the immunity can turn on that distinction.
So, Your Honor, I don't believe if it were collected in other mechanisms, I do not believe that there would be speech or debate immunity. You'd be right back to Kilbourne. How's the sergeant at arms going out and arresting this person, right? That was the Kilbourne case. And there was speech or debate immunity in that case for the congressional actors that were passing that resolution directing the arrest, but not for the sergeant at arms that was carrying it out, that illegal Fourth Amendment. So, again, we're not in
So you don't contest at all the fact of the actual enforcement of the mask wearing during this process? Because again, to Judge Rao's point, you're focused on the reduction of the fine.
I think you have to focus on the act of the enforcement to appropriately analyze speech or debate immunity. In other words, are you making somebody stand in the well of the House? Are you dealing with proxy voting that is core sort of speech within the House, that is core methods on how that House votes? Are you dealing with something that takes it outside of the House, which is the Powell case on pay, and it also happens to be, the arrest?
But again, my question is, so should we assume that in terms of the actual enforcement of the mask wearing, you're not having any issue with that? You're just focusing on the pay issue.
Your Honor, it is the enforcement is the fine, right? That is, in terms of, hey, he's been given a notice, or hey, he's going to be censured or reprimanded, I think that's probably speech or debate. I think where it stops being speech or debate is when you go and you take something out of somebody's pay. And now we're right on point.
See, I think you're right that you focus on the act. But the act here is the resolution. And you don't look at, the courts say, Ravel in all cases say, you look at the act, not the act. And here the act is the resolution, right?
No, you're not.
No?
And again, we know that that's the case because of Powell. In Powell, there was resolutions that were directing, in that case, the exclusion of Congressman Powell and the deduction of his pay. The resolutions, and again, I think Powell, the speaker, actually got.
Say again how you explain the press gallery case in McCarthy.
Those are access cases, Your Honor, to the Hall of the House. I think that's on point more.
Isn't that what this is?
No, Your Honor. This is the deduction of pay. This is the deduction of pay.
It's a deduction of pay for coming onto the floor of the House without a mask.
That's true.
It directly relates to the legislative process.
Your Honor, I think that inappropriately focuses on the substance of House Resolution 38 rather than its enforcement mechanism.
Okay, I hear your point. Let me ask you a different question. Suppose instead of requiring masks, the resolution had required a negative COVID test with the same fine structure. Would you be here challenging that?
Your Honor, if they had their pay illegally reduced, then yes. Because again, the question is, was there a rule enacted and the enforcement that immediately took effect to change the pay without an intervening election?
So is there any way Congress could have passed a resolution that wouldn't have run afoul of a mask or a negative COVID test? Is there any way it could have done that?
Your Honor, they could engage in what I would call traditional enforcement mechanisms.
Which is what?
They could censure, as was the case in Wrangell. They could reprimand. They have the power to exclude if they can get the 2/3 votes, as the Constitution requires under the Discipline Clause. Mm-hmm. There's a full panoply of enforcement mechanisms available to them. What they cannot do is vary compensation without an intervening election under the plain text of the 27th Amendment.
Well, if there was a censure, though, would that still leave in place the plaintiff's First Amendment claims?
Your Honor, I think the defendants may have speech or debate immunity under Wrangell if it were a mere censure. In other words, if it were not something that was going beyond actions within the House. Voting, for instance, is protected under speech or debate, and that is the McCarthy case. We know that reprimands and censures are under the precedent in Wrangell. What takes this outside of it and puts it on all four with Powell happens to be the deduction in pay. And because of the enforcement mechanism, for instance,
suppose we agree with Judge Child's point that this isn't a reduction of pay because it's just a deduction of a fine. In other words, the pay is still the same. Then how does that affect the speech or your view about this?
Your Honor, that I think puts labels over what is actually going on here because it is a deduction in pay.
Well, what about the withdrawal? What about the withholding of income taxes? Is that a withholding of pay?
It could be, Your Honor,
Really?
except that
Do Congress, the members of Congress have pay withheld?
they do.
Well, why isn't that a violation of the 27th Amendment?
Because, Your Honor, that law has been a record. The withholding has been a record, and there's been multiple intervening elections since that law.
I see. Okay. What about health care? What about a member of Congress who during the term changes the kind of health care they have?
Your Honor, in that case, there's consent, and consent obviously would, obviate a number of things. For instance, we allow searches and seizures with consent that would otherwise not be permissible under the Fourth Amendment.
So if someone's income goes up during the 2 years, if someone's total income goes up for, forget that.
Well, Your Honor, and again, you'd have to look at what that is. Is there a reimbursement scheme that is already been in existence prior to the intervening election, or is Congress voting themselves additional stipends or additional per diems, which would trigger the 27th Amendment? Here, no matter what label you put on it.
So suppose during the term of a Congress, in the first year of the Congress passes a tax law which increases the tax rate that results in greater withholding during that term. Is that unconstitutional?
Your Honor, I think the tax scenario is different than the punishment scenario when we look, for instance, specifically, and I'm looking at the Article 3 compensation cases that the United States Supreme Court has adjudicated for a long period of time. There was the holding that was a violation of the Article 3 compensation clause. And then obviously in the early 2000s, the U.S. Supreme Court said, you know what, it's generally applicable to everyone. And so it isn't going to govern that. I would say that the same analysis would apply here. By the way, the reason we don't, and what the U.S. Supreme Court said in that case was, we're not going to allow the punishment and the deduction of judicial pay for individual acts because that's punitive, that's coercive. Those same principles are at play here as well.
Mr. West, can you point me to any cases in which a court has adjudicated a claim by a member of Congress, against congressional leadership or other parts of Congress, where we haven't kicked the case out on standing, political question doctrine, speech or debate immunity, or what this court used to call remedial discretion? I mean, are there any cases in which a court has heard that type of dispute?
Several, Your Honor. One, of course, we've been talking about a lot this morning is the Powell case itself, which was a case about pay. The other one that I would point out, and the court reached the merits and found that there was not a 27th Amendment violation, was Boehner versus Anderson. And in that case, this court did reach the substance of the claim and said, hey, there's not a 27th Amendment violation because the statute that was enacting the COLA had been of record and enacted prior to the session. And the fact there's automatic increases, that's just a formula, but Congress had voted it. So those aren't jurisdictional issues. This court reached the merits in that case. Obviously, the U.S. Supreme Court reached the merits in Powell.
But in Powell, he was no longer a congressman. Isn't that right?
I would have to go back and look. My understanding that he was, but even if he was not.
And the basis for the court hearing it was that there was a pocketbook injury to him in his personal capacity.
Correct. And that pocketbook injury is present in this case as well. Your Honor, are there any other questions? I know that I'm over.
Another question?
No.
Judge House?
No.
Thank you.
Thank you.
May it please the court, I'm Douglas Sletter, the General Counsel of the United States House of Representatives, and we urge that the decision by the district court be affirmed. What if I'm going to just jump in on various points. In answer, I think it was to your question, Judge Rao, my friend said, well, the Boehner case. I happen to know that case very well because I was one of the attorneys. I was representing the President of the United States, who was one of the defendants. So my friend is right. There were congressional officials, officers who were defendants, but the President was. And so we couldn't argue speech or debate immunity to get rid of the case because the president was a defendant. The court, I think, has shown that it has not only read the briefs, but read the DC Circuit and Supreme Court opinions. This notion that because my friend relies on that because they're suing officers of the House, it takes it out of speech or debate. That's been just absolutely, completely rejected. The Supreme Court rejected it in Gravel and Eastland. This court most recently rejected it in McCarthy. The recent cases are all ones that I've argued before this court or the district court. The exact same argument was raised. It was, well.
I also didn't see him focusing much on Gravel. And there's kind of that two-step process about it being an integral, deliberative, communicative process that we're talking about, again, the mass policy. They don't seem to dispute that. But then you also have the issue about, is this within the jurisdiction of the House? He seemed to have skipped over to just, this is a fine being implemented to the mass policy. Reducing compensation.
I'm a little hard of hearing. I think I apologize.
I don't think he focused on Gravel at all. Right. Is my point.
Yes.
So I guess what I'm asking you is, don't we have to go through that analysis?
Your Honor, the Gravel analysis is what Judge Walton did. Judge Walton said Gravel sets a two-part test, and therefore that's why Judge Walton felt that he needed to examine whether this was a reduction in compensation. We're fine that he did that, but we don't think it was necessary. And for example, the opinion I called to your attention more recently, the recent district court decision by Judge Kelly in Clyde says that the speech or debate clause immunity is not limited by other parts of the Constitution. So you don't need to reach that issue. But as I say, Judge Walton did, we think he absolutely, and is citing Gravel, that there are 2 points. And so as I say, we think it was unnecessary, but if looking at it as alternative ways of reaching the same result, we're fine. But I think that particularly the McCarthy decision by this court shows that the key question, as this court has understood the Supreme Court is saying, is you look to see is this integral to the legislative process. And
well, when I asked plaintiff's counsel about McCarthy, his answer was that the difference is that the staff who had speech or debate immunity were involved in the legislature. They were involved in enforcing the proxy rule, that is, the voting in Congress. Whereas here, what they're doing, and I'm just repeating what he says, there's nothing to do with the voting in Congress. It's the deduction of pay. And that's the distinction he makes. What's the matter with that?
The matter with that, Your Honor, is the reduction in pay is obviously part of the scheme that the Congress, that the House set up here, was the limitations on access to the House chamber and the enforcement mechanism.
Well, he said they weren't excluded from the House. They were just fine. That's his whole point. And in fact, I think he said, Congress did have the authority. There would have been speech or debate immunity if what Congress had done is expelled them from Congress.
Right. I believe I think he did make that concession to you, which I found very interesting. But Your Honor, let's look at McCarthy. McCarthy was a remote voting scheme. The way that scheme is implemented is by the staff. The speaker doesn't,
but the staff was, I assume the act was, the staff was registering a remote vote, right?
And I think it's more than registering. They set up the whole system.
Correct.
And make it work.
Right. But his point is that has to do with voting, whereas this case is about the deduction of pay. I get your point that, well, the deducting of the pay is the way you enforce the resolution. But his point is that it's fundamentally different because the deduction of pay has nothing to do with the voting. In other words, the plaintiffs in this case could vote. That wasn't what was being interfered with here. They were deducting their pay.
Right. So let's look at Consumers Union, which Your Honor first asked about, and I don't think I ever heard an answer there to your question. Consumers Union was a staffer who was then charged with determining and enforcing who and how journalists could come into the House chamber.
Yeah, access to the chamber.
Right.
It's part of the legislative process.
Well, the fine system here is the way of enforcing the access to the chamber. So to me, these are very similar and quite analogous. If I could also, I think Judge Rao asked, is the focus on the pay in Powell versus McCormick, the key thing, the reason that the Supreme Court addressed that is that, as you just said before, about standing and mootness. And so the court said, well, we do have a continuing controversy because Mr. Powell at that point still had a back pay claim. And then the court, the whole analysis of what was going on there was back the pay that was then deprived because he was excluded rather than expelled. And the main part of the court's discussion was that he had to, if they were going to do this, he had to be expelled rather than excluded. So I think that it is really having the tail wagging the dog by making it seem like what Powell was about was the back pay. That's why there was still continuing jurisdiction. But that's not what the case was about. But
Can we
how do you
separate those issues?
No, you go ahead.
Go ahead with Judge Tatel. Go ahead.
No, you go ahead.
Did you have,
I was just following up on Powell. I mean, okay, I get that point, but how do you distinguish Powell's speech or debate analysis from this case?
I apologize, Your Honor. Again,
Sorry, how do you distinguish? How do you distinguish Powell from this case? Setting aside the standing question, the Supreme Court did hear his claim.
Because in Powell, what the court there focused on was the actions of the officers of the House who were carrying out the function, who kept Mr. Powell from being able to come on the floor and vote, etc. Since Powell, more recently in Eastland and Gravel, the Supreme Court, without discussing what happened in Powell, made absolutely clear that the speech or debate protection applies as well to the actions of the non-member officers and officials of the court. And that is exactly what then this court applied in McCarthy and Consumers Union. So what we now know is from those more recent Supreme Court opinions is you can't say, well, this is different because we're talking about the administration of what Congress did, because that exact argument is rejected at least twice by the Supreme Court and by this court most recently.
Mr. Letter, just a framing question. Do you think that the speech or debate immunity is a jurisdictional bar to this court's consideration?
This court has used that exact word, Your Honor.
Right.
So this court says it is jurisdictional. It's not clear whether in other courts of appeals or in other circuits, I'm not sure whether any of them have said it, but this court specifically has. Now, as Your Honor knows, maybe better than I do, there's jurisdiction and there's jurisdiction. So what exactly does that mean? Maybe you're aware of just the other day, Judge Nichols decided a case.
He said it was jurisdictional, following some decisions of our court.
And we agree it is jurisdictional. In that case, we said the House did not raise speech or debate. It wanted to get to the merits of the dispute, and we said that the House has the ability to do that. Judge Nichols said you can only do that maybe through a clearly expressed waiver. And even then, he said maybe there is no waiver because in the Olstowski case, I think it is the Supreme Court raised questions about whether there can or can't be a waiver of speech or debate.
Well, if it goes to our subject matter jurisdiction, it can't be waived.
It can.
It cannot be waived.
Cannot be correct.
If it goes to our subject matter jurisdiction.
Right. And so Judge Nichols held that, and he therefore dismissed Mr. Meadows' case. And so at least his view, which obviously is not binding on this court, is that it cannot be that the House has to assert speech or debate if it wants it to be part of the case. And that was the argument we made was it's like the Fifth Amendment. It's something that it's not self-executing. It has to be asserted by the party.
So then it's the
Judge Nichols rejected that.
But it's the House's position that it's not. It doesn't go to subject matter jurisdiction.
Again, it's very hard for me to know exactly what this court means when it says that it's a subject matter jurisdiction determination. There, in our view, there clearly has to be situations where if the House does not invoke speech or debate, the case is properly before the court, unless there are other reasons that it's not. Again, Judge Nichols took a different position. Now here, and I know you started out, you said something out of curiosity or something like that. Obviously, it's not posed in this specific case.
It's an interesting question.
Right, but we'll see. Mr. Meadows sought reconsideration before Judge Nichols, and maybe he's going to appeal. I don't know, so it might get to this court, and we might learn from this court exactly what this means about that it's jurisdictional.
And I just want to be clear as to whether or not you believe the mask and the fine issue can be separated, or are they integral to each other because the fine is the enforcement of the mask policy?
For speech or debate purposes, Your Honor, we think they are integral. Okay. Because this is all from our perspective, this is all part of the same scheme, because the question is we've got the policy about masks. Now, how is it going to be effectively enforced? If it can't be effectively enforced, it raises a question about the practicality or the purpose of the mask requirement. And the House decided that the best way to enforce it was through the fine system. And I might add, pages 43 and 44 of our brief, we explain that the system of fines for members who violate House rules is well established in the House. And by the way, the House operates very much on a precedent and history system. And so we cited there for you, there are various cases where there are fines, because this is one of the ways that the House can effectively carry out its rules about decorum and discipline, et cetera. So it's a well-established power that the House uses. Indeed, I have to say, I think it would be a remarkable ruling by this court about really affecting the separation of powers if this court were going to start interfering with the House's ability to fine its own members as discipline. Remember, we're not talking about fining anybody else. We're talking about fining its own members. And this court, in various cases, First versus Black and Brown and Williamson, et cetera, has made clear that this court believes, and we think correctly, that it has very limited function in affecting the way that the House operates itself. So I think that would be. Thank you very much, Your Honors.
Mr. Weiss, we'll give you 2 minutes.
Thank you, Your Honors. A couple of points in rebuttal. First, I have never heard a limiting principle from my colleague about their view of speech or debate immunity. I suppose, in their view, if we wanted to go back to flogging, there would be no.
Well, before you get into that, that's not especially helpful. So, could you respond to two of his points? Number one, that if you look at Gravel and our cases, Consumer Union and McCarthy, that there is no distinction any longer between the actor and the act. That's what those three cases stand for, and you know, it's the Supreme Court and our case law, and they clearly do say that, and that therefore, you know, the distinction that Powell rested on there just is no longer something we can do. What about that?
Yeah, let me address that, Your Honor.
Right.
Yeah.
Okay.
First of all,
Then I have a second question.
right, Gravel dealt with a committee process. That is a core function of what the House is doing. Just like, by the way, McCarthy did. Just like, by the way, Consumers Union did. Access to the hall of the House. When we look at Powell, and by the way, I want to correct the record. I did reread Powell. He initially got, you know, his pay reduced in the 90th Congress, and he was reseated in the 91st Congress. He was a sitting member of Congress when that pay was reduced. So this distinction about, well, it may be different depending on whether he's not a member of Congress. He was a member of Congress when that pay was reduced. It was a different session. As it may be in a couple months, it's going to be a new session of Congress. But again, we're dealing with something that's outside that core legislative function. Not
well, but what about Mr. Letter's point that he said it's not outside? He said this goes to the heart of how Congress disciplines its members, which the Constitution gives directly to Congress, and that there are many rules that Congress adopts that are enforced just this way. And that, let me just finish my question, and that if this court were to question that, it would raise serious separation of powers concerns.
Your Honor, that simply is not true.
Well, I thought you might say, but why?
Right. It's not true for several reasons.
Yeah.
First of all, it was not true in terms of the reduction and the withholding of pay in the Powell case. Secondly, they have numerous means that they have traditionally used, whether it's depriving people of committee chairmanships, which in fact they did in one of my clients, whether it is
well, was Mr. Letter wrong that this procedure of deducting pay has been part of the way in which Congress enforces its rules for decades? Is that wrong?
When it has happened historically, Your Honor, it has been very rare, and all of that occurred prior. And again, the 27th Amendment was initially part of the original Bill of Rights, and obviously it sat on the shelf for a long period of time prior to its adoption by the states. But ultimately, the rules changed under the 27th Amendment in the mid-90s, and there's been very, very few cases that have addressed that issue. This is really a case of first impression in terms of what are the limits on Congress and what they can do. Can they line people up and shoot them outside? Well, obviously, the 8th Amendment would not allow them to do that. It would probably be a de facto expulsion as well. He would suggest, Your Honors, that there's no limit to that. That speech or debate, it's enforcement of their rules. We could strip them to the waist and flog them like we did back in the 1800s. It's enforcement of their rules, speech or debate immunity. There is no limiting principle that limits at all his view of speech or debate immunity. And yet we know courts protect rights.
We are talking about fines that have been established over time, like that's been their precedent as a way of enforcement.
Your Honor, it has occurred very, very rarely, and when it has happened generally, other than no one has challenged it after the adoption of the 27th Amendment. And so I don't think you can look to historical practice when you've got an amendment that changes. That's the very point of an amendment. And the point of an amendment is to change the status quo. For decades, for instance, we did not allow certain categories of persons to vote, and yet we amended our Constitution to change the status quo. The 27th Amendment changed the status quo in much the same way. We cannot
vary. You need to get us beyond speech and debate clause before we would even need to reach 27th Amendment.
I can, Your Honor, and obviously we think Powell is dispositive of that question. The other cases that they cite deal with functions within the hall of the House themselves, not varying pay, not administrative officers bearing pay, which is Powell. Again, he was a sitting member of Congress. So all of these distinctions that they try to draw, when it comes to pay, that's 27th Amendment. And this distinction that he said, well, the president was a party in Boehner. Well, then why didn't you dismiss the legislative defendants and the legislative actors in Boehner that were implementing, right? They would ostensibly be subject to it. And the reason that was not the case, I would submit to you, was because Powell precluded that argument.
But you see, you're getting into the merits of the case as part of the speech or debate analysis, and the whole purpose of speech or debate immunity is to keep the courts out of the merits.
Your Honor,
So it shouldn't make any difference for purposes of speech or debate what the 27th Amendment says. The question is, can the defendants here be held accountable in court for what the defendants say is a legislative act? And we can't resolve that by, we're not allowed to resolve that by looking at the merits of your 27th Amendment case.
Your Honor, I would submit.
Isn't that right?
Well, the speech or debate jurisprudence always looks at the act, and that's what I've been focusing on. What is the act that's at issue here?
Yeah, you look at the act, but not the legality or constitutionality of the act. You
That's
look
true.
at the act, and the defendant's position here is that the act is an integral part of the resolution.
Your Honor, if that were true,
Yeah.
and that position were true, and that was the same position, by the way, that these same defendants articulated in Powell that the United States Supreme Court rejected. If that were true,
Well, what do you do with grovel?
Your Honor, grovel was a committee issue. It's just like McCarthy. You're dealing with the internal functions for Consumers Union. You're dealing with access to the House and the internal functioning of it versus an outside administrative function in pay. That's the distinction. And again, if there were not a United States Supreme Court case right on point, I would say that they might have a stronger argument. But here there is. And they have failed utterly to distinguish the holding in Powell. We're dealing with employee actors who are enforcing a pay decrease, and that was the issue ultimately in Powell as respects to sitting member of Congress. So I did want to just very, very briefly.
Just to clarify, the plaintiffs here are bringing this suit both in their individual and official capacity.
They are, Your Honor. And the individual for the pay that they're due, the official, because if the pay is diminished, we start to deal with congressional independence. And so that's the official capacity issue. I wanted to finish on this in terms of this distinction of it's not a pay decrease, it's a fine. If you go back, Your Honors, and you look at the U.S. Supreme Court's discussion in U.S. versus Hatter, that was the 2001 Article 3 judicial pay case, they said it's not a problem that the taxes are uniform. It becomes an issue of independence. And if you go into the sleeper article that we cited, which this court's also cited in some of its jurisprudence, it talks about the development of the 27th Amendment. It's all about the independence of members of Congress individually to be able to articulate and have sustenance. That's why, in part, we have the ascertainment clause. That's also why they did the 27th Amendment, to ensure independence. That was the same guiding principles that drove the Article 3 compensation clause. What the U.S. Supreme Court said in Hatter on Article 3 is, hey, look, it's okay if it's a uniform tax because that's not punitive, that's not directed at anybody. But we're going to have a real problem if you start to find judges because you don't like the rulings. That's a violation of the Article 3 compensation clause. I would finish with suggesting to this court that the same is true when it comes to a violation of the 27th Amendment. We start to get into, and this is right out of Madison, I wanted to finish this, in Hamilton, in the Federalist. If you control a man's pocketbook, you control his will. That's what this is about. And the 27th Amendment takes this form of enforcement off the table. Thank you, Your Honors.
Thank you. Case is submitted.
Case number 22-7012, Jabari Stafford, appellant, versus George Washington University. Ms. Knapp for the appellant, Mr. Schwartz for the appellate.
May it please the court. Jabari Stafford's hostile environment claims are timely because a 3-year statute of limitations applies to Title VI claims brought in the District of Columbia. When a federal civil rights statute does not include a limitations period, courts borrow from the most appropriate state statute of limitations. This borrowing inquiry must consider both the substantive and procedural characteristics of the relevant federal and state laws, as well as federal interests in predictability, simplicity, and minimizing litigation. We know that the procedural comparison is critical from the Supreme Court's decision in Burnett and this court's decision in Banks. And procedurally, the DCHRA's private cause of action has little in common with Title VI's, even though both laws include a private cause of action aimed at eliminating discrimination. And that's because when the DC Council set a 1-year statute of limitations for the DCHRA's private cause of action, it emphasized efficiency concerns that often characterize administrative remedials.
How do you know that? Is there legislative history that supports that?
There is legislative
What is it?
There's legislative history that supports that we rely on in our reply brief, but we don't even need the legislative history here because it's in the text of the DCHRA provision adding the statute of limitations that there's a tolling provision that says that filing an administrative complaint tolls the judicial limitations period. So a DCHRA plaintiff can add years to the time they have to prepare for a lawsuit and to accomplish all of the tasks that the Supreme Court in Burnett describes as involved in remedying injuries in court simply by filing this form complaint with the DC Office of Human Rights.
Is there anything, I know under Title VI, individuals who believe they're discriminated against, say, in federally funded programs, that's what Title VI is all about. They can file a complaint with the Department of Education, right?
They can
file. Are there any cases that talk about whether the statute of limitations is tolled for that period of time?
The statute of limitations is not tolled when an individual files a complaint with OCR. And
is there a case that says that?
There's not a case that I'm aware of that talks about a lack of tolling, but we know, for example, from Cannon and from Sandoval that the administrative remedies are entirely distinct from the private cause of action here. And so, for example, Justice Scalia talks about in Sandoval how the administrative remedies are, quote, twice removed from the individual who is actually seeking relief through the private cause of action. And GW makes this point for Stafford when it argues that he could have filed a complaint with OCR, which in turn could have sought to terminate funding to the men's tennis team. But that would have been no help to my client who wanted the benefit of playing on GW's tennis team without daily racial harassment and humiliation. And so turning to the substantive comparison between DCHRA and Title VI, the substantive comparison doesn't make the DCHRA an appropriate analog in light of the procedural mismatch. And in any case, distilling the essence of a Title VI claim reveals that it is best characterized as a personal injury action. And that's because the Supreme Court has repeatedly explained that invidious discrimination is a fundamental injury to personal rights. And Wilson and Goodman and Owens also emphasize these federal interests in uniformity, certainty, and the minimization of unnecessary litigation, all of which support the simple approach of choosing the personal injury statute of limitations that the parties here initially agreed applied to Title VI claims. And so it makes sense why courts have repeatedly borrowed from personal injury limitations periods for anti-discrimination statutes, concluding that it's unlikely that the limitation period for personal injury actions would be inconsistent with the remedial goals and policies of federal civil rights statutes. Now,
so is your point that is your point about being inconsistency that it's inconsistent with the notion that there's no administrative remedy under Title VI? Is that what's inconsistent?
It's inconsistent that there's no administrative remedy, but what's more important is that there's no tolling. Because the DC Council, when it was setting a 1-year statute of limitations for the DCHRA's private cause of action, was doing so at the same time that it was setting this tolling provision in place, which would mean that an individual would have much more time to accomplish the tasks that Burnett lays out as involved in filing a complaint in court. So, for example, Burnett explains that when an individual is not seeking to redress discrimination through administrative remedies, the person must identify that they've suffered a legally cognizable injury, search for, retain, and figure out how to pay for counsel, or, as in this case initially, prepare to proceed pro se, conduct enough investigation to draft pleadings that meet the requirements of the federal rules, establish the amount of damages, prepare legal documents, pay a substantial filing fee, and this list in Burnett goes on. And when the DC Council set the one-year statute of limitations for the DCHRA, it knew that someone would have likely far longer than 1 year to accomplish those tasks because they simply needed to file a form complaint with the DC Office of Human Rights to stop the clock on the statute of limitations for their private cause of action. Now here, Stafford's student-on-student harassment claim is also timely because he filed suit within a year of experiencing a hostile educational environment that GW allowed to fester through deliberate indifference until January 2018 when my client left the school, and he filed suit within 1 year in November 2018. Now, hostile environment claims are different in kind than claims about discrete discrimination, which accrue on the day that the discriminatory act occurs. For a hostile environment claim, all instances of harassment contribute to the discrimination claim, so the clock does not start on the claim when the hostile environment is ongoing. And so the clock did not start on the cause of action on which my client filed suit until he was no longer experiencing the harassment, and that was after January 2018.
How does a continuing violation factor into your analysis?
This is what I'm referring to now, that under Morgan, because my client experienced harassment through January 2018, the clock did not start on the statute of limitations until then. So even if this court rules that a 1 year statute of limitations applies, his student-on-student harassment claim is still timely. And here, there is no dispute that the environment, which GW concedes constituted severe, pervasive, and objectively offensive harassment, it did not change from year to year. The types of acts were the same, constant use of racial epithets, including the N-word, porch monkey, and ape. This is JA3 at 880 and JA2 at 599. And racially fueled plots. This is JA3 at 936. And the harassers were the same. So although they added new teammates to their ranks, they were always led by team captain, CR. And there was no intervening act that can be attributed to the university that even attempted to change the atmosphere. So this means that the harassment was ongoing within the year that Stafford filed suit, and it's attributable to GW's ongoing inaction, and Stafford's claim is timely filed. Now, GW's argument that...
I just had a question. I mean, so the district court here had an alternative ruling, right? So the 1 year statute of limitations applied, but also did an analysis if a 3 year statute of limitations were to apply. I mean, in your view, if we were to agree with you that there was a 3 year statute of limitations, then what would be the appropriate disposition here? Would it be to remand to the district court?
Yes, it would be to remand for further proceedings, and our assumption would be that those further proceedings would be trial because the court has already explained how it would rule on the merits here. That being said, it's our view that our client's teacher-on-student harassment claim is also he'd also be entitled to bring that to trial because here there was notice to the university and deliberate indifference to that teacher-on-student harassment claim.
Will we need to make a ruling about continuing violation?
Not under the circumstances that a 3 year statute of limitations applied, but in any case, again, here, the harassment continued until January 2018. My client filed suit within a year of that time. And also, to be clear, the deliberate indifference was also continuing through that time because the notice that GW had all the way going back to my client's freshman year was notice of the same hostile environment. And here, deliberate indifference, we have quintessential deliberate indifference, and that is a failure to act. And so that failure to act didn't occur on any particular day. This series of omissions continued through January 2018, and my client filed suit within a year.
But do you understand GW's claim to not really challenge the harassment?
That's right.
We're here really on which statute of limitations issue.
Which statute of limitations applies and whether or not GW acted with deliberate indifference.
Any further questions? No. Thank you.
Good morning, Your Honors. May it please the court. Jason Schwartz on behalf of George Washington University. Let
let me address the statute of limitations issue and the points that my colleague made. This analysis starts with Del Castello, where the Supreme Court has commanded the test is two parts. Plaintiff.
Before you get to your rationale, tell me about what was allegedly an agreement on the statute of limitations initially.
In GW's motion to dismiss, we assumed that there was a 3-year statute of limitations that applied. Judge Cooper considered the full 3 years worth of allegations. He dismissed certain claims, did not dismiss others. In his ruling on the motion to dismiss, he pointed out that in his view, and I'll explain why that's correct, it was a 1-year statute of limitations. So under Rule 12, when we answered the complaint, we asserted the 1-year statute of limitations. It's not possible to waive that statute of limitations argument prior to filing an answer, as Judge Cooper found. That's where that comes from, Judge Johnson. The inquiry...
Before you get into the... I see where you're going on your argument about the statute of limitations. I read your brief, but let me just ask you kind of a big picture question about this. I mean, we've got 3 Supreme Court cases here, Wilson, Goodman, and Owen, and they involve 1983 and 1981, two civil rights statutes. And the court says, look, these civil rights laws, that these civil rights laws are all for all of them, the proper statute of limitations is a personal injury statute of limitations. These are all personal injuries, and Title VI is exactly the same. And I don't see how, given those cases and the rulings for 1981 and 1983, how we could possibly distinguish Title VI.
Understood, Your Honor. I think there's a material...
That's my big question. Yeah.
I think there's a material distinction there, Judge Tatel, and that is those cases are Reconstruction-era civil rights statutes where both this court in Banks and the Supreme Court in the cases you mentioned have said, essentially, there is no perfect state law analog because the whole point of those statutes is to capture a wide variety of conduct, and we need to be able to predict in advance what statute. The conduct could be anything from excluding jurors on the basis of their race to saying you can't bring a case in court on the basis of your race to providing negligent medical care to a prisoner, all sorts of conduct.
Sounds like Title VI.
Respectfully, Your Honor, it's not. Title VI is much more targeted. It's a spending clause statute on discrimination.
Right, it is. But the type of discrimination that's captured under that is extremely broad. Right?
And Your Honor, not
it is,
in
and
this,
the courts have said that Title VI is a broad civil rights statute.
It is, but not in the sense of the Reconstruction statutes that are specifically.
So your theory is that it's not. I don't know of any. I'm sorry, but it certainly can't be that 1981 and 83 are Reconstruction era, and this one isn't.
Well, Your Honor, the Supreme Court.
This was passed. This was passed in 1964.
Absolutely, Your Honor. And the Supreme Court explained that the Reconstruction era statutes are designed specifically to override state power. Therefore, there is no state statute of limitation that is easily analogous. Instead, we jump to the default personal injury that sweeps broadly. Here, when you look at any of the spending clause statutes, Title VI, Title IX, or the Rehabilitation Act, the trend in the cases is to say these are different, especially here in D.C., where you have a broad D.C. Human Rights Act that covers hostile educational environment. Hostile educational environment is much more like hostile educational environment than it is a car accident, the statute of limitations that Mr. Stafford proposes. And so if you look at the cases, the D.C. Court of Appeals in Jayola has said that. 4 judges of the district court, Judge Nichols, Judge Cooper, Judge Boasberg, and Judge Kolar-Catelli have said that. The Court of Appeals cases, circuit courts outside the D.C. circuit that have looked at this question, where they have looked at spending clause statutes designed to capture discrimination and state law human rights statutes that capture the same kinds of discrimination, there are 3 cases that go our way, all from the Fourth Circuit, Wolski, McCullough, and Moore.
Are those Title VI cases?
Wolski is a Rehabilitation Act case, McCullough is Rehabilitation Act, and Moore is Title IX, Your Honor. So all parallel spending clause statutes.
My understanding is that all the circuits to decide this issue under Title VI have said that you should take a state personal injury statute. Is that?
Not quite, Your Honor. So there's only one Circuit Court of Appeals case that has compared Title VI to a state human rights statute, and that is Eggerdall. The other cases are just looking at personal injury versus breach of contract or specific intentional torts versus general catch-all personal injury. The only two cases that look at either Title VI or Title IX and compare them to a state human rights statute and come out against us are Bogar, and in that case, the Court of Appeals said...
Aren't they in part not comparing to human rights statutes because of Wilson and Goodman and the Supreme Court's decision in those cases?
I don't think that's right, Your Honor, because the Supreme Court specifically explained that the reason that those statutes require general personal injury is because they literally have a litany of all different fact patterns, some of which require intent, some of which don't. It could be anything from, again, voting to other forms of discrimination to negligent health care. There's no way to shoehorn them. The only Supreme Court case actually that addresses a state human rights statute is the case that addresses the Maryland human rights statute, which at that time did not provide for a private cause of action. So it both had this Reconstruction era element of much broader than the spending clause statutes, and it didn't have a state analog. Here, we have a state analog. Again, 3 of the 5 courts of appeals who have considered this fact pattern say that our answer is correct. And then if you look specifically at the D.C. Human Rights Act, which is exactly the inquiry that the Supreme Court has commanded, whatever other state statutes might say is really irrelevant to this. What does D.C. Human Rights Act say? An apple is like an apple, not grapes, right? So a claim for hostile educational environment is on all fours with the D.C. Human Rights Act, hostile educational environment, not a catch-all for car accidents.
So in your view, ruling for you wouldn't create a totally lopsided circuit split?
That's correct, Your Honor.
You are very narrowly parsing what these other circuits have done.
Well, I think actually wouldn't create a circuit split at all because Del Costello has a very clear analysis the Supreme Court has told us. The Supreme Court cases do not direct the outcome here. 5 cases, 4 judges in this circuit, district court judges, have concluded that these spending clause statutes are different. The D.C. Court of Appeals has concluded that the D.C. Human Rights Act is directly on point. If you look at the reply brief, page 8, the plaintiff concedes that Title VI and the D.C. Human Rights Act address similar substantive concerns. So the only way they get to a different answer is by flipping the analysis upside down and saying, well, the process is different. That, too, is actually not true. Both Title VI and the D.C. Human Rights Act provide the claimant with a choice. You can pursue the administrative remedy or you can go to court. You don't have to exhaust the administrative remedy.
But
the
if you
Office for Civil Rights,
what counsel was saying this morning, or under the D.C. Human Rights Law, if you do the administrative route, the statute of limitations is total.
That is correct, Your Honor.
Is that true for Title VI?
I don't know the answer to that. The court has not addressed it.
I think the answer is no.
Your Honor,
would that change your view about this?
It doesn't. And the reason that is not dispositive, there are a couple of reasons. Number one, as Your Honor may be aware, the administrative filing period with the Office for Civil Rights is 180 days. The statute of limitations we would be borrowing here from the directly on point D.C. Human Rights Act is 1 year. So a plaintiff would literally get double the amount of time. If 180 days is sufficient by federal judgment.
Suppose the agency doesn't finish, suppose OCR doesn't complete the process within the 1 year period.
I would imagine that the claimant would have an argument at minimum for equitable tolling in those circumstances, Your Honor.
It's a pretty risky place to rest your claims on equitable tolling.
Well, again, I don't think that tolling is dispositive here, Judge, because if you look at the rule that I am advocating, which is literally the rule of Del Costello, right? Look at these 2 statutes. Are their essence the same? And if the essence is the same, is there a federal policy that would be defeated? Obviously, a federal policy wouldn't be defeated by picking a 1 year statute of limitations because, for example, in certain other states, the statute of limitations for personal injury is 1 year. So that can't be an overriding policy choice. In fact, in some states, the statute of limitations under the State Human Rights Act would be longer than the default statute of limitations for personal injury claims. So it's not an outcome-oriented thing here. 1 year is a reasonable period. And in fact, you had asked, well, has the DC Human Rights Act and the DC Council considered this? The answer is yes, because subsequent to the DC Court of Appeals decision in Davis, the DC Council amended the Human Rights Act to add a 1 year statute of limitations period for actions filed in court. So they made that judgment, not just on the basis of administrative process, but as illustrated actually by the facts of this case. When discrimination cases get older, memories fade, evidence disappears, and justice is delayed. This is not a pro-defendant or pro-plaintiff.
That would be true for a 1981 or a 1983 case also.
That's certainly true, Your Honor. And as I said, in some states, the statute of limitations for those causes of action would be 1 year. Now, in 1981, there's a little footnote, as I'm sure you're aware, the subsequent to the Civil Rights Act of 1991, a federal statute of limitations was imposed for certain 1981 claims, but I don't think that's relevant to this consideration.
So in Wilson, I want to ask you another question about Wilson.
Yes, Your Honor.
Wilson says that when looking at a question like this, we are to apply the statute of limitations, quote, or that quote, fairly serves the interests vindicated by the statute. So if we look at that, and if we have a choice between a 1 year and a 3 year statute, I mean, wouldn't a 3 year statute, isn't it fairly obvious that a 3 year statute would much more effectively vindicate, quote here, fairly serve the interests vindicated by Title VI by ensuring that victims of discrimination in federally funded programs have a 3 year statute of limitations, not a 1 year statute of limitations?
Not at all, Your Honor.
No?
In fact, first of all, the point of that statement in Wilson, as I understood it, was to say that the full scope of Section 1983 actions, as pointed out in Wilson, could include discrimination in public employment on the basis of the First Amendment, discharge or demotion without procedural due process, mistreatment of school children.
I mean, wouldn't we, I'm sorry,
indifference.
I know that list, but wouldn't we, I just viewed this statement as Wilson as stating the obvious to a court, which is that you interpret a federal statute to accomplish its purposes, consistent with its goals. That's what it's saying here.
Your Honor, I don't disagree, although I think there are two points I would make to that. Number one, the point of Wilson was that it is a panoply of actions that don't neatly fit
just
anywhere.
Focus on my question about interpreting.
Yes, Your Honor.
Forget that I asked you about Wilson. When we interpret a federal statute on a question like this, don't we try, one of the things we look at is what is the purpose of the statute?
I don't disagree with that.
Wouldn't a 1 year statute, as opposed to a 3 year statute, limit the effectiveness of Title VI? That is, the goals that Congress was trying to achieve with it.
No, Your Honor.
By forcing people to file their cases in a more limited period of time.
Your Honor, I don't accept the premise that longer is better for plaintiffs. Remedy for discrimination should be swiftly provided. If you look at the sister statute, for example, Title VII, the claim has to be filed within 180 days or 300 in a state with its own parallel state agency. And again, if you borrow the statute of limitations for personal injury, in some states that would be 1 year. Or if you look at this court's decision in the case that involved the Education of the Handicapped Act, it's selected as the most appropriate statute under the Del Costello framework, the DC statute for appealing administrative orders, which was 30 days, Your Honor. So longer is not always better for the plaintiff. Which case was that? Hold on, I'll give that to you in just one moment, Your Honor.
Don't tell me I wrote it.
I'm sorry?
It's not my opinion, is it? No, I'm serious. I just don't remember the case. What case are you talking about?
Just one moment, Your Honor. I'll get that.
Okay.
Apologize. I thought I had that at my fingertips.
Well, you can send it later. Don't worry about it now. You can submit it later if you'd like.
Oh, I'm sorry, Your Honor. It's the Spiegler case. And there, the court chose a 30-day statute of limitations as opposed to 3-year general personal injury because petitions for reviews of orders of the school district with respect to the education of disabled children It was in the interest of the statute, both plaintiff and defendant, for those to be promptly disposed of. I would argue here again, it's in the interest of all parties, particularly college students or students at a secondary or even primary education, that the claim of a hostile environment be dealt with swiftly and resolved. So that's in the interest of all parties. Again, I don't think the statute
Well, the
purposes.
counsel for plaintiff in this case does not agree with it.
I understand that, but this is not a results-oriented rule in each case.
No.
It's an application of Del Costello.
But she's looking, her argument is that we're not just deciding this case, we're setting a rule for all of our cases under Title VI. And her argument is that a 3-year statute of limitations more faithfully executes the purposes of Title VI.
And the only way, first of all, I disagree that it faithfully executes the purposes. And if you look at Davis, the D.C. Court of Appeals made clear it wasn't just about administrative expediency, that discrimination cases should be dealt with promptly, that is a policy goal. And again, if you apply the rule of personal injury statute of limitations, it just happens that in D.C., the car accident statute is longer. In other states, it could be a year or shorter. So if you faithfully apply the rule, as again, with all the spending clause cases, 3 of 5 Court of Appeals decisions, Wolski, McCullough, and Moore come out our way. 4 judges in this district have all come out that way. Judges Nichols, Boasberg, Polar-Catelli, and Cooper. And again, what the plaintiffs are asking you to do, the plaintiff is asking you to do, is flip the inquiry on its head. Start with some sort of extra statutory reason as opposed to are apples like apples. These statutes are the same.
And do we need to do anything with the continuing violation theory?
You don't, Your Honor. So I think Judge Cooper was clear that it did not apply in this case, but I think you don't even have to get there because Judge Cooper found, notwithstanding what you've heard in sort of a new case presented on appeal, that in accordance with the local rules, no acts were presented that took place during the statute of limitations period. That's reviewed for abuse of discretion, and it clearly was not an abuse of discretion for him not to permit consideration of those after the fact, not in the Rule 7 supposed quote-unquote facts.
Thank you, Mr. Schwartz.
Thank you, Your Honors.
Ms. Smith, we'll give you 2 minutes.
Thank you. I'd just like to address that forfeiture point. Nothing has been forfeited on the continuing violation argument. GW did not argue below that Stafford had failed to point to acts of harassment that occurred within 1 year of when he filed suit or within 3 years of when he filed suit. Instead, it argued only that Stafford was required to point to acts of deliberate indifference within the year before filing suit. And this makes sense that that was the only argument that GW made in its motion for summary judgment because at the motion to dismiss stage, the district court had rejected GW's argument that it could not consider events outside the limitations period if Stafford pointed to an act of harassment occurring within 1 year of when it filed suit. And here, the record makes very clear that acts of harassment were occurring through January 2018, and my client filed suit less than 1 year later. So we know, for example, that during Stafford's senior year, the harassment, quote, intensified. This is JA 3 at 936. And he consistently testified that the harassment occurred on an everyday basis and in everyday conversation. This is JA 3 at 935. In any case, the court would not need to reach this issue if it agrees with Mr. Stafford that a 3-year statute of limitations applies to Title VI claims in the District of Columbia. And for all of these reasons, we'd ask that the court reverse and review further proceedings. Thank you.
Thank you very much. The case is submitted.